So there is a no mention day, right? Huh? Please ask me what it is. What do you want? Which we can mention for other groups, not for this. What is the urgency? You can wait till home. What is the urgency? You can't wait till. No, no, tomorrow you can mention before regular court, right? Huh?
Today, big mention all the procedure.
Yes, sir, you can mention tomorrow. What, one day, what difference will it make here?
Tomorrow is time for attachment there, no court. Let me say tomorrow itself, that's what I am asking.
Mention tomorrow before the appropriate time. Yes,
They had to call one day before.
yes, yes. Issue notice on IA 1 of 23 and Rule 4.2. So no interim order. Yes.
Your Lordship,
Third,
is not.
on the question of admission in this.
From this honorable court, my lord, that they are taking suitable, my lord, steps for amendment.
Notice has to
nothing-
be issued, right, in this case
The-
also. No, in other case, let's see if they have taken a stand, then we can list.
Obliged.
Yes.
Your Honor, I'm a party in person petitioner. This petition is filed challenging the various of the enrollment fee of 27,500 rupees that is being expected from me to be paid by the State Bar Council. Basis which I
What
filed.
grounds?
Your Honor,
What ground?
the ground is that the Parliament of India has decided under Section 21, Clause 1, subsection F of, Section 24, subsection 1, Clause F of Advocates Act of 1961, Your Honor. Parliament has decided the enrollment fee is 750 rupees only.
Where? Section 24.
1F, Your Honor.
Read. So you still have not been enrolled?
I have not, Your Honor.
And still filing, like how many petitions you intend to file before
Your Honor, I
getting
wanted to
enrolled?
enroll last Monday itself. Unfortunately, the amount of fee that the
Advocate.
State Bar is
1 minute.
expecting us is.
So you are, if you are dependent on the result of the petition, then it will take time. It can't be decided like today.
Your Honor,
So
I'll read it.
fine.
Your Honor.
What the Advocates Act prescribed that
Yes, Your Honor.
750.
It has been also upheld by a division bench of Honorable Kerala High Court as well that any fee beyond 750 rupees is illegal and ultra vires the section
Which
itself.
provision?
Section 24 1F, Your Honor. One of the conditions
1 minute.
he has paid in respect of enrollment
1
stamp
minute.
duty.
1 minute.
Sorry.
This is not a moot court competition, right?
Sure.
Where, I mean, we are giving you 2 minutes time. If we don't understand, who will be at loss?
I'll-
We are looking at 24(1)(f) and you are reading something.
Readings.
Main ground is that it is in contravention of section 24(1)(f), right?
Yes, sure.
So then what is there to read about? Yes, party in person.
Your Honor, a small submission, if I may, please. Initially, I was given a 17,500 rupees quote, Your Honor, but the moment I informed that I worked for 16 years and I left my job to pursue my full-time employment and then wanted to enroll, the one of the leaves was exchanged and it was substituted with a 27,500 rupees because I have a gap from what they say. And it's been 3 years since I have.
What have you challenged in this levy of enrollment fee of 12,500, right?
No, 27,500.
It's not 12,500.
No, it's
Right, madam.
27,500.
27,500.
So
Yes.
24,500 is being taken by the State Bar Council, Your Honor, 3,000 rupees of.
Whatever we have issued
Yes.
notice, if you can't understand,
I
mean,
did.
we will appoint an amicus for you who can tell you what is the procedure in a court of law. We have entertained the petition, issued notice to respondents. What are you arguing for?
I wanted to request if the court can be, I'll be grateful if the court can grant my IA number 1, Your Honor.
What IA number 1? You should be enrolled without payment. That is the issue to be decided. You make payment, we will direct refund. Bar Council will not run away. We are sure. It's not at flight risk and it has not taken any loan from financial institution. So therefore it is not at flight risk. You can safely deposit whatever amount and get yourself enrolled instead of waiting for the outcome. We will have to seek their response. Any relief by way of an interim order cannot be granted, which has the effect of allowing the petition itself. That is what you want. And today itself you want enrollment. Can't be done.
Obliged, Your Honor. Thank you.
Where is the IA 1 of 2 of 23, Mr.? You have filed, no?
2 of 23.
You have filed amendment, no?
Yes,
Yes. Where is that? It's not in the yesterday.
it was.
Yes, yes. Right. All right. What is it? Indian Stamp Act. This is WP pill, right?
Yes, but that is WP pill, my lord.
They are opening some other, Mr. You better don't do it. This is other case. Tell him this is item 4. Where is IA 2? Please, we don't have it on record yesterday. Please give a copy if you have.
What else?
Madam, get the copy of IA 2.
I'm sorry, but I'm having only one copy.
No, you have filed it, but it's their fault. It's on account of some
I'm sorry.
digitization. It's not taking place. We asked him about this amendment. You have this thing, no, made the amendments, correct?
Yes.
That's what we wanted on
Yes,
the
ma'am.
last. Bill.
It says that the Honorable Court may please to permit the petitioner to amend the pleadings in para 5
What
of the
reading, what amendment you want?
by incorporating that the case status proceedings pertaining to the
Which
See-
paragraph?
para 5. Para 5 of the main writ petition, main writ petition.
Ah, where is the amendment? Amendment.
Amendment by IA2.
No, no, that is what amendments you want to incorporate. That's
You know,
what
these case numbers and all these things.
all. Heard on IA number 2 of 20.
Shri Kumar Upadhyay and others.
Give that. Yes. In this
Amendment. I have to file a typed copy.
you said I will do it today. That's why.
I thought that
By tomorrow. Heard on the question of admission and then issue notice.
obliged, deeply obliged.
It has come as an office objections,
Huh?
not,
See how, ask him how we can grant a declaration, the public interest declaration that the land is assigned land. No, no, declaration. Please read the prayer clause. What is the relief you are seeking in this PIL?
the relief you are seeking is, blood, the land can only be inherited, cannot be alienated.
No, no, no. Sir, please read it for our benefit. We have not read it. You please read it for our benefit. And whether such a sort of a declaration can be granted in a writ petition under Article 226.
The issue here is, Muller, what I'm seeking is, Muller,
No,
there is a
please see.
GS number
No,
140.
no, no. For the reasons stated,
More particular, one is nature, writ of manvers, call records, person survey number so and so in GOMS number 1406 so and so, declare the same as assigned land.
declaration of the land as assigned land, perhaps we cannot do. This is our
Maybe, Muller,
duty to you.
I had to file an amendment to this, Muller, I'll file an amendment to this prayer, Muller, because in fact, assigned lands should already assigned lands. I think by oversight, Muller, that it means I need to correct the prayer, Muller,
You are an advocate.
I'm sorry, Muller, I'll do that.
Petitioner is an advocate and you are also an advocate.
True, Muller, but
Both of you have not read it. The burden is on the court to read it and
No, no, no.
point it out, right?
I'm sorry, but I'll take steps to amend the prayer.
After going through the prayer clause. Oh,
This bill is filed, my lord, against the inaction of the revenue authorities in not taking action on the representations made, my lord, to the respondents to protect the
What
government.
is your locus, right?
My lord,
Who are you?
I am a villager of the very same village.
Ah.
Name is Kompalli, but it is part of Pet Bashirabad.
Have you gone through the office, this thing note?
My lord,
There, office note.
no, my lord, I have read notes.
Huh? There are criminal cases. The office note says that there are criminal cases registered against you in this, in respect of the same land which is the subject matter of this public interest
Against the
litigation.
encroachers.
You have also filed a criminal complaint. So therefore, the office note suggests that it is not a public interest litigation, but you are a person personally interested in the land.
No, there is no question of me being personally interested in it because it is a government land. The land belongs to the government. My
No, no,
endeavor
whether the fact that the criminal cases are pending against you has been disclosed by you in the writ petition.
I am not.
You must come to the court with clean hands, Mr. In a
I'll-
public,
I'll-
that too, in a public interest litigation.
Litigation. I'll seek the clarification from the AOR, my lord, then that should be posted after.
In view of the objection raised by the this contempt petition has been filed alleging violation of the interim order.
Proof of service. Yes, USR number 1 of 2023.
Madam, is it on record?
May it please your lordship.
I pay for first respond file counter.
Hmm.
I filed a counter for first respond both matters.
May. Because the writ appeal raises the question as to whether, based on an injunction granted in a civil suit, in a writ petition, police protection can be granted. Our court has held that that cannot be done. Dehors facts of any case, police protection in a civil suit, which is subject matter of civil suit, cannot be extended in a writ petition. The facts leading to the matter is, my lords, your lordships had occasion to hear earlier applications for condonation of delay, because the delay is because we were not parties to the writ petition. And after the writ petition was filed, an order was granted, and the police came to dislodge us from our admitted possession of the property in question. An appeal was filed before this honorable court with leave. Your lordships condone the delay.
Can we ask him one question before? Yes, Mr. Have you
Always
seen
your-
this order dated 9/8/2023? We have passed an order in this appeal.
Yes.
His grievance is confined to the fact that order of injunction has been granted in favor of respondent number 1, which pertains to land bearing survey number 184, 185, 186 and 195. And whereas they have made construction on 194/8/1.
Exactly, my lord. So,
Therefore, the police cannot dispossess that.
No.
That is the grievance.
My lord, there are some.
That is the grievance irrespective of the order. So perhaps
I can.
you will agree, you can't say that police can in the garb of police protection can dispossess him from this land.
No, it's not as simple as my friend would say it, because these people these people on the very same ground.
No. One thing, we will, of course, we will have to hear him in that
I
case.
can answer that point.
Oh, no, but like if the property is not covered by an order of
Yes.
police protection or injunction, then perhaps
They cannot, my lord, police cannot dispossess any party who is not party to the injunction order while implementing, my lord, the injunction order is a principle. It's
yes,
well taken.
that's
not
what,
different.
you can't.
But facts of this case.
No, but
is-
this what you have you seen this order, please?
Yes, my lord. My lord, now
9823
that
order.
order was obtained, my lord, when I had not filed the counter. And when now the counter is filed, two facts are brought to your lordship notice.
No.
One is-
We have only recorded his grievance, not like we have not granted any order. 982023 we have recorded the facts.
There is a status quo order now granted in this writ appeal. Now therefore I filed a counter, bringing all the facts in notice.
No. See, please, have you seen order dated 9823? Please.
9820.
So there his grievance has been set out. There is no order granting earlier. It may have been-
Earlier there is an order of status quo.
All right, but see the grievance, like we had heard him at length, and thereafter 2-page order we have passed. If you have not seen, please see. We will take it up day after tomorrow.
Oblige.
I'll just check.
Please see. 982023. You please read, and then we will hear.
I was here.
We'll take it up day after.
Lord, Lordship have it on Monday.
Monday.
Monday is a holiday, my lord. Students' day.
14.
Tuesday.
15. Tuesday. 14. Learned Senior Counsel for a ten 9.
Oblige.
Yes.
I beg to appear for the respondent, writ petitioners.
Yes. What is to heard finally, Mr. Advocate General?
8 acres of land, my lord, in a residential locality now. My lord, sir, what is sought to be set up there? My lord, in 94, the purpose which were for which that those were intended to be allotted. In fact, my lord, sir, if we go to the merit of the matter, when, my lord, sir, the decision of the.
So we'll hear it sometime next month.
Just
Next
give me 1 minute, madam. Land allotment.
No, but this is on admission.
Matter has gone to Supreme Court inter partes. Supreme Court has given a judgment.
The clause is totally different. Now, the present clause is totally different.
Page 56, Malad, is judgment of Supreme Court inter partes.
No, that's why taking into account the nature of controversy, we are giving a date for hearing. You can mention on that day. Which date, Mr. You tell a date of your convenience, any date.
Malad, your lordship, Malad, may give a date, Malad, early date.
Yes, Mr. Advocate General.
My lord, sir, subject to your lordship, sir, any day convenient to your lordships, my lords.
21st November?
Yes.
Yes.
20. No other case, no matter. 21st November.
In fact, notes also, my lord, we have filed the note for that will assist your lordships, my lord.
21st November.
That I am appearing 15 time, item 15 minute. 14 is.
14. 14, nobody is appealing.
Both are connected. Same order, two writ appeals.
There also appears in item 14. The last occasion or that you find some founder or something. He has not touched.
So shall what, pass over or what?
I give it.
My lord, I am appearing for the appellant counsel, my lord. We have filed the reply, my lord.
Item 14.
Item 14.
Yes, madam.
Care
What is the order passed by the learned single judge? Disposed of with the direction to respondents 1 to 3 to consider the application submitted by the petitioner number 1 for entering his name. Right? That's the order, correct? You can also be heard by the authority. What is there? We will modify the order to that extent.
Yeah, I said.
Ah.
But in fact, the order before the learned judge, with due respect for the consent order,
Ah.
the learned judge accepting, not writing the word consent.
Ah.
It was a consent order.
Ah.
Post the passing of the order by the learned judge,
Ah.
we go file a case.
Ah.
We go before the appropriate authority.
Ah.
Appropriate authority grants an order of status. Suppressing that fact, they file the present intra-court appeal. Questioning the status quo, they file another writ petition.
You have already entered appearance before the authority, right? You will be heard, madam. What is there? Nothing, no case for interference.
Not one submission I have.
Ah.
Not there is no consensus.
No, may not be any consensus. We will not
No,
proceed on that.
my friend has been stating that.
No, no,
There
we
was
will
a
not.
consensus that is not correct.
No, the fact remains, Mr. Please,
Correct.
1 minute.
Yes.
Is it incorrect that after the order of remand, you have appeared before the authority? Which authority?
Joint collector.
Joint collector. And an order of status quo has been granted.
No.
So you will also be heard, not appeared.
No, one submission.
All
That
right.
we appeared, that's the fact.
Then-
But the thing is, having set aside all the orders of the revenue authorities, the learned judge says, go before the same authority. Instead of directing them to go to civil court. You know, there are disputed questions of fact.
No.
They rely
Civil
upon
court means whether joint collector will declare the title of the petitioners.
No.
No.
Yes, the entire
It's
proceeding.
an entry, we believe in the revenue record, correct?
Yes, that is the,
Does it confer title?
no.
Even,
It will
and
not.
will it not be open to challenge at your instance if an order is passed after
Well,
hearing you,
well,
even assuming against you?
You know, I am the protected tenant. I purchased from the landlord in 1959. Now they come forward in 1989 saying that they also purchased from the same particular under an agreement of sale. You know, they should enforce the agreement in a competent civil court, but not before the revenue authorities.
That is for them to choose their remedy. They
Yes.
know that the remedy before revenue
But the
authority will not
remedy-
confer any title.
But the landlord judge direct the petitioner to approach again the very same authority. Instead of, your lordship, may I read the impugned order for a minute?
No, the order has been passed. All right.
Yes.
Please argue.
Yes.
Even in civil court, they go with the revenue report. No. It's an order under section 9 of this Mustazar Passbook Act. Still it agreed, then they can go to civil court. Because civil court, the primacy is the title of the court. Yes.
May I read the order? It's a very short order. At page, it starts at no purpose will be solved by going before the same authority which has decided. And all the orders have been set aside. At page 18 of the impugned order. Lordship got it. Paragraph 3. A perusal of the order passed by the respondent number 2 dated 21/2015 shows that respondent number 2 has gone beyond jurisdiction and issued various directions which are beyond the scope and original application dated 5/11/93. The simple request that was made through the said representation dated 5/11/93 is to enter the name of the petition number 1 in the revenue records in the possessory column. But the respondent number 1, it's all about the plan. Then your lordship may kindly go to page 20, that is the relevant paragraph 5. However, taking into consideration that the request of the petitioners is for entering their names in the revenue records in possessor column in respect of subject lands, Also taking into consideration the fact that the Act 1971 was repealed by enacting the Telangana Rights in Land and Particular Prospects Act 2020, respondent number 3 herein cannot now consider the application dated 5/11/1993 that was submitted by the petition number 1 for entering the name of petitioner in the person column. In the circumstances, this court does not find any reason to remand the matter back to the respondent number 1, 2, 3 herein and deems it appropriate to leave it open to the parties to agitate their claims in accordance with law by initiating appropriate proceedings. Now they are taking a clue from there. After 60 years, they file a appeal before the joint collector, questioning my certificate under 38(6). And of course, I have an opportunity, I will find out. That is different aspect. But directing the authority, petitioner, by setting aside all the orders, they should go before the civil court for entries. Under the amended act, Lordship, I kindly see, there is a remedy. Section 7 of the Telangana Rights in Land and Particular Prospects Act 2020. Is not that they have no remedy. Section 7, affecting change in record of rights. Lordship got it. Affecting changes in record of rights when acquired through court decree. Any person who acquires right by decree of a court and seeks to change the entries in record of rights shall apply through the website prescribed for this purpose to the Tahsildar for allotting available date and time. This is the mode they should obtain a decree and then approve. Then
No, if a court decree is passed, then he can apply under section 7.
he should have gone before civil court when we are disputing the very.
Gone before, then challenge that the order. What is wrong with this order?
Now they go before the same revenue authorities instead of going to the court.
They can go anywhere.
I can't.
We can't issue an injunction
I can't.
and restrain them from prosecuting even if according to you the remedies is Please appreciate our limitation.
With respect, my lord, I submit when there are disputed questions, the only remedy to the parties left is, your lordships are well aware, you have to go before the civil court. They are basing upon their claim the agreement of sale dated and
we are not concerned. That is pending adjudication before an authority. That is not the scope of a writ petition to declare the title of a property. That you cannot be held, that it can't be held in writ appeal that you are the owner of the property.
No, I'm not saying. Directing the other party before the appropriate authorities at this stage, after 40 years, 30 years. That is my submission. Having held that all the orders have been set aside, the letter says, para 5, para 6, in the circumstances, this court does not find any reason to remind the matter back to the respondents 1 to 3 here and deems it appropriate to leave it open to the parties to agitate their claims in accordance with law by initiating appropriate proceedings.
We don't say that. This court doesn't learn. It doesn't say go before joint collector. Right.
Authorities, not civil court. I leave it to the court, man. I can't. Yes, sir.
You understand.
Yes,
Your experience tells.
and I can't say further.
Yes. This intra-court appeal
May I please, Lord? My lord, this petition is filed, my lord, concerning the action of
The reply affidavit has to be filed
Yes,
by
sir,
you.
the fifth, seventh respondent filed their counter.
Huh?
And as per the directions of this honorable court, the pollution control.
No, if you don't want to file a reply affidavit, we can proceed because you had short time last date.
I'm sorry, my lord, I forget to file.
Huh?
My lord, in spite of that, my lord, pursuant to the counter filed by the seventh respondent, which clearly shows that no permission was granted by the Gram Panchayat. And the illegal.
No, no, we will go ahead, right? We will go ahead.
The construction.
So you don't want to file any reply, elaborate counsel for the petitioner.
Well, last I kindly have it next week, my lord, I'll file.
You have been granted time for that.
I'm sorry, my lord, I forget to file, my lord.
If you don't want to file, last date you sought adjournment on this very ground.
Sorry,
And today you are arguing. I mean, that's why a clarification.
I have forgotten, my lord, that for that I have apologized, your lordship.
Don't forget. It's
I'm sorry.
dangerous. And in any case, it's a what? Public interest litigation, right?
No,
That's why.
It's not public interest litigation, my lord, because my lands are situated adjacent to the land in which the client respondent is going to establish ready with stand.
Then all the more necessary to remember what you did last date.
Sorry,
Yes.
I'm sorry.
For 2020 itself, they were declared as fraud.
Where is the order?
That order was not communicated.
I'll counter.
Yes, Lord.
How much time?
2 weeks time. Lord.
Respondent praise warrant is granted 2 weeks.
No order is passed even according to them.
Lord,
That's
Lord, as per my
the problem is, Mr. That if he is a young man not realizing the consequences of not following the counter. He orally making a submission. Supposing if we allow the petition, the bank will file SLP saying that the High Court did not grant us opportunity. We cannot tell the bank that your counsel did not pray for adjournment to file counter. This is our predicament.
But
We have to tell the lawyers what to do.
last occasion, my lord, there is a direction to give those dates. My lord. Already there is a direction.
So where is the dates orally?
Lord,
File an affidavit.
yes, Lord.
Praise warrant.
Yes, Lord. I'll file my count on that.
Praise warrant is granted. Executing your remedy before DRT, what is there? We will see. We will have to examine more closely this issue which you have contention you have raised, because just a contrary argument has been made by us, made before us in another rate petition filed by the bank about this applicability of this Rajesh Agarwal and all that.
Yes.
We'll have to consider. If you want to file, otherwise don't file. We will record your statement that you don't want to file counter.
We'll file. We'll file, my lord.
We will file or want to file. There is no question.
I want to file count of that, sir.
Says
Only to file.
praise warrant is granted 2 weeks time.
Bless you.
Please, your lordship. May I request for passover, my lord?
What?
This is a matter.
You have challenged the validity of second proviso to section 18.
But it's already been upheld by the High Court. The division bench on this, at his instance, has upheld. And now the question is only on a matter of fact. And the other aspect is, when
One minute. Did you disclose this fact in an earlier petition? In your rate petition that it was already been upheld?
Yes, madam.
1 minute, let's, please. As it is, he is in difficulty, right?
Sorry.
Yes.
Madam, it is page number 13, madam.
Have you disclosed that it has been upheld?
Yes, madam. It was disclosed. It was
It has
disclosed.
been upheld. So that now, any question of this thing?
Under the provision 2, my lord, there is a
Not provision, proviso.
sorry, provision, my lord. The court has a discretion to waive up to 25%, my lord. I have been asking that with regard to 25% only.
No, Mr. Have you not challenged the virus of this provision in the petition?
Earlier, I have challenged, my lord. Not in this, my lord. In this, my lord, I have challenged the order wherein they have asked me to deposit 50%. Wherein the court has a discretion.
What is wrong?
My lord, there is at page number 4, my lord.
Issue preferably debt recovery appellate tribunal. Yes.
The lordship permits me to read, my lord. The honorable court may please to issue a writ or order or direction more probably in the nature of writ of certiorari and calling for the records and challenging the order.
Yes. So why for seeking waiver of the amount you have to make out circumstances? Why it should be? Because you are a borrower, therefore nothing should be recovered. You shouldn't be asked to pay anything.
No,
Bank should be asked to deposit some amount.
No,
right?
I've been asking only 25% because the appeal over here, my lord,
SRPC Act.
appeal over here is not against on the merits of the matter, my lord. There was a condone delay application filed along with the essay. That condone delay application was dismissed by the court, by the Honorable DRT. Against that dismissal of the condone delay application, my lord, I have gone to an appeal before the DRA. Wherein I have been seeking for a waiver of that 25%, my lord, from 50% to 25%.
Madam, this SRPC Act, what? You don't even listen to what is Securities Contract Act.
But I just want to interrupt your lordship's thought process for a minute. I've got to say something.
Let his senior come. We will hear you when at length.
Because
Here means not here on admission, he has to argue.
yes, he has challenged Manoj is at page 106A, which is a consequential order. The tribunal saying that Manoj, in view of the dismissal of the earlier application for coordination of delay, the appeal itself is dismissed. That's the order he challenges. Against the earlier order, he files a writ petition and withdraws that.
What has been done?
The coordination, the refusal to condone the delay, against that he filed a writ. That is dismissed. Rather, the writ petition he withdraws. Now the order is only a consequential order in view of the dismissal of the application for condonation of delay. The main appeal does not survive and therefore it is dismissed. It's just a consequential order. That's what I'm saying. 1066 if you're not fixing.
My pleading is, my lord, the interim order merges with the main order, my lord. Therefore, the earlier writ petition which was filed was withdrawn and subsequently this writ petition has been filed. Therefore, in the prayer I have also written clearly with regard to this order is consequential to the order.
106.
1066.
In volume 2, page 1066 is the impugned order.
106 we don't have.
Annexure P28.
1066.
1066.
Yes.
Oh. So what have you challenged, mister? What happened? Give us the facts.
May I seek for pass over my senior counsel is reading.
All right.
Much older.
Pass on. Yes. Affidavit of Mr. Prasad, affidavit of Commissioner Panchayat Raj.
According to to file the affidavit with regard to the election day, state has to file. Not should be declared
Obviously, it can't be held right away. You will agree. We will have to defer the hearing. Learned counsel for respondents pray for.
Obelisk.
Mr. Yes. So, Mr. What we feel good about is Mr. Prabhakar.
Yes,
that
to the children, Milord.
what we feel good about you is that you always start with a smile. That's very good.
I'm deeply
People are so serious that they forget to, like, as if something is, they are being hanged right away. And
blessed.
so, at least, I mean, you appreciate that we are only trying to find a legal solution to the solution to a legal problem within four corners of law.
Yes.
What is it?
My lords, last time, my lords, I have taken time to file count in IA.
3 of 23.
The IA count is being filed during the day today, my lord.
Okay.
I have also served a count.
Shall we take up on Tuesday?
I have
in
put
November?
submission with great respect to this honorable court. I have found few lacunas where the guidelines have not been followed. I'm submitting before your lordships as well as.
No, but let them file counter, you go through it.
Yes.
They are filing it today, Mr.
Yes,
Prabhakar.
Lord, earlier they filed one
Today.
additional counter filed today morning. And in those two also have found few lacunas. I am submitting before your lordship.
We are here to set everything right.
I am submitting to him
We will take it up on
correct the same.
14th November.
Bless.
You tell him. Yes. It is not an adversarial litigation.
Yes, yes.
Whatever has to be done, we have been telling you since this thing, flood victims, we have been telling you that we will set this thing right.
Deeply oppressed.
Learned counsel for respondent. After 2 weeks then. Or
Date
what?
may be given.
Date 20th November 23.
Deeply oppressed.
Counter.
Not by. Counter not by that.
How much time?
3 weeks, sir.
Let them file counter. Learned counsel for respondent.
Minutes, status report has been filed, my lords, in this. There are 11, my lords.
So all this thing, cold storage boxes are functioning.
My lords, every day, my lords, about 20 to 25 bodies are received, whereas the capacity, my lords, was 60. My lords, during COVID, my lords, about 8 storage units. Yes. My lords, now that in the there are 62 freezers which are all, my lords, are functional, but every day, my lords, from the requirement is 20 to 25. The certain, my lords, 6 units. Those were, my lords, repaired that is not required. That requires a requirement. But my lords, as of now, there are 62 freezer boxes available, whereas the requirement every day is 20 to 25 of the freezer boxes.
So all 62 are functioning.
Yes, my lords.
So this was done after the news item, or you have?
No, my lords. In fact, my lords, 60 which were there, my lords, only 6 of out of 60 were not functional. Out of 60, 6 only were non-functional.
And thereafter you have made them functional.
No, my lords, excepting 6, all were functional prior to the, my lords, this news item even.
And now every
62, now 62 are functional.
so you have taken remedial action.
Yes,
in this
yes,
respect. Right. Yes. Yes, madam. This petition.
Three to four bodies are generally not identified, my lord. Other bodies are generally.
You say received out of which 3 to 4 are not identified.
mobilized.
Yes. 20.
It's an expedite petition that filed by them.
May
4 of 2020.
We'll consider sometime in next year. Right now, the focus is on the old cases, right? Let IA 4 of 20. Password. None for the petitioner when the matter is called in second round. Mr. So and so learned senior counsel for respondent. Next week.
Please, in one matter, my lord. Yesterday they filed an IA.
1 minute. What is 20?
24 to 44, this is a batch, my lord. In item number 34, yesterday late hours, they filed an IA. Inter alia stating that proceedings initiated under old act of 1894 would get lapsed under section 24 of the act 30 of the present act.
1 minute. This is 24 to 44.
Yes, my lord. If that is,
these are 2005 matters.
Yes, my lord. The amendments raised in the IA yesterday filed go to the root of the matter, my lord. We have to file a.
Nothing, Mr. No, what root of this?
They say that is proceedings or proceedings initiated under old act have lapsed under section 24 of the present act, 30 of 2030. If that is the case, oh my lord, that goes to the root of the matter. That your lordship may please to grant us 1500.
Mr. This 2005 matter, Mr. Please cooperate. What is this?
That is true, my lord. I am aware of
it. Is like, see, Mr. Only 29 matters are left and we will come up to straightway up to 2008. This is one of those matters.
Your lordship may please.
You know, forget why you want to need this thing file IA, Mr. at the 11th hour. You argue what is the.
I have filed only on the basis of their counter before.
Don't file, you withdraw that IA. He is seeking an adjournment.
The matter.
What root of the matter?
That may be passed, some order may be passed. It's purely a legal rule. And in fact, the Honorable Supreme Court, while remanding another set of batch of matters in 2015, has given that liberty.
How much time do you want? Let it read. Why we should toil? There's no time. No, if your bar is not willing to cooperate, what can be done? Let it be adjourned. What is there? The Additional Advocate General for Respondent submits. If they want to file, they can do so.
In this period, they can, so that it can.
Needless to,
proceedings, my lord. Insofar as item number.
Needless to state that state government, if so advised, can. He is not praying for time. Why should you bother? In case it is so advised, it can file counter. list after 15 days.
Insofar as item number 30 and 32
No,
confirm.
how it has been adjourned, Mr. On that day, another, this ground of adjournment you should keep reserved after 15 days, another ground. We are not now, there's no point, right? You can't be blamed for adjournment.
Well, they have become infractions that can be disposed. We have withdrawn the item number 30 and 32. We have withdrawn the proposal of acquisition. So therefore, they have become infractions that can be
30 and for my benefit, right?
No, my lord.
That we are doing it.
We'll be ready for hearing in item 30.
No, don't, Mr. Don't seek an
Go
adjournment.
forward with it. I am just not.
Those grounds are not ready to be disposed of, my lord.
Huh?
30 and 32 may be disposed of
Yes,
as infractions.
in this. We are, even if anybody is unwell,
My lord,
it has to be done on a mission mode basis. It can't happen, Mr.
But when you will be repeating the case, to allow
Yes.
the case will be.
32 also same order, dismissed. Survey number will change, no, that you will do, or should I tell? 14, write down 14687 of 2005. In this writ petition, comma, pleading to seek an adjournment will be entertained. This is a clear write down. No, it is also made clear that no interlocutory application made by any of the parties with an object to seek an adjournment shall be entertained by the court, and no further adjournment on any ground. And we will give a date, because it will not after 15 days. What is after 15 days? What is the date?
28.
Huh?
28. November
15 days?
28. 28th of this month.
That will be the last day of this case in the court. That we can promise you.
I do it.
With your last kindly.
No, 1 minute. Yes. What 15 days? What is?
Exactly 28.
23rd only. So it comes up on 28th November. And no application. Don't file any application. Root of the matter, this thing, whatever, root of the matter or top of the matter, whatever it is. We will not entertain, it's very clear.
Once. My four matters.
Which?
Have not.
1 minute, one minute. What, which case IA? 37? 35. 35. Petitioner number 2 and 4.
Yes,
So we should declare apart from this thing that you are the owner of the land.
I'm not claiming that, but I'm contesting before the lower court, my lords. Only my rights may.
You have purchased the land, right? After the notification. So what is the
Subsequent.
if you purchase the notification land after land is notified for acquisition, what is it? It is void.
No, some
That
plot
is the
owners,
effect.
some plot owners have.
We will consider. It will not be adjourned, Mr. on any ground, right? Even if it is allowed, you be ready to argue the case. It will be telling you again.
Yes, sir.
Very clear. With a heavy heart, we are adjourning this, but don't seek an adjournment and embarrass us. We will not grant, Mr. We are telling you. This is recorded. No IA will be entertained. Nothing will be done.
My lord, with your lord,
Yes.
I am appearing item 31. This item 31, my lords, I am ready with the matter. I am not taking that ground which other councils are taking. I am appearing item 31. It can be allowed if he is wishing to argue.
Can be allowed.
Yes, it can be allowed. It's covered by Supreme Court judgment. The ground that 54-2 is there, it's against us because of Manohar Lal versus Indo Development Authority. The ground won't stick. The other grounds will stick, man.
So
the writ petition can be allowed.
Allowed?
Yes.
Now, without arguing, it is allowed.
Your Lordship, what I'm saying is that it's a covered matter and I'm not seeking adjournment just for the sake of it.
So, this is a bunch, right?
Yes.
Therefore, we will take it up.
Yes,
Please come ready on the, if you are prepared, then nothing to lose. These people have to prepare the cases.
With your lords.
They have to prepare, they are not ready. Oh, get better.
With your lordships kindly.
Yes.
With your lordships kindly. One matter of mine is a connected matter, your lordship.
We don't know, Mr. We-
Not listed, your lordship. Same acquisition.
You make a mention at 10:30. No, again that day he will seek adjournment.
I'm not seeking your lordship to club it.
No, we don't know. Mr. Then other that day, they will say that some other case and this thing.
There are two.
You please file an application, we will link it. Please file an application for linking and make a mention, we will link it.
No,
But
the
this,
connected matter is already there where I just now we have said
maybe this is, Mr. that your case is not.
matter, sir. Same subject matter. Both are appearing, same subject matter. There is another repetition file after the directions given by the.
Permitted to mention the matter on this point of time at 12. 11.
Benefit of 24-2 and file an application. I have filed an application along with a writ petition. That is 33388 of 2014. That is connected, same acquisition, same land. Your lordship, it's a clubbed. Your lordship may kindly order to be clubbed. I am prepared to argue at any time, whatever your lordship fixes. The government is there.
Or anything else?
That's it.
Yes.
My lord, four of my writ petitions pertaining to Gopanpalli, same survey numbers, same acquisition.
Please,
Not
there is a procedure, Mr. We, in this garb of their petitions, we cannot permit mentioning at 11:50 PM, AM, right, PM. We cannot permit this 11, this is mentioning. And we don't know what is their case, what is your case, just an oral statement. There is a procedure. You file an application for linking of your petitions along with these petitions. We will give notice to them and list it if they agree. Otherwise, your petitions will be ground for adjournment. We don't want to do that. These cases will not be adjourned under any circumstances, Mr. We have told you. Come what may, these petitions will not be adjourned on 28th November. That is for sure. Whatever. If you have to file an application, assign reasons, file an application for linking, seek mention memo at 10:30 a.m. We will take up your application and list it, but not without notice to the other party. Not like in a manner, haphazard manner. Later on, anybody, we have seen this happening. One council got the cases delinked.
No, what?
And then next week, she said before us that I cannot argue because material documents are in those cases, it be linked again. Then we told her, Madam, you got these cases delinked. She said, I never made such a submit. This is, we can't permit. Yes. Please file an application, own the responsibility, sign the document.
My lord, 45. My lord, serial number 45. I'm representing TVL Narsimha petition.
45? Up to 44? Okay. See. Really? We would have made it. Yes. This is a public interest litigation, right? Are you the owner of Tank Lands? Huh? Green Belt, then? He is the owner of all properties. What is the prayer in the petition? Green belt areas, tank beds, proposed railway track. You own a railway also, right?
No.
That
At that
community facilities area.
At that time, the petitioner was the secretary of the industrial unit. Respondent number 5. He was the secretary of respondent number 5. So we have filed the writ petition to challenging the validity.
Mister, this is a public interest litigation. It is unfortunate that you don't even know that this is a public interest litigation. This is a public interest litigation, right? We have taken cognizance now. What is you can't seek an adjournment.
Posted on Monday, my lord, just 3 days. My senior will argue in detail, my lord.
There is nothing to argue in a public interest litigation. Since you have received suffered a bereavement, we will adjourn. But you should realize, right? And read Mr. Decision. You have a beautiful library, right? Inaugurated recently. Have you ever been there? Do you sit there and make use? Nothing. We assure you that you will not, you will be benefited if you spend some time in the library, right? Read today what is Sheila Barse versus Union of India, 1988 decision of the Supreme Court on public interest litigation. You cannot withdraw this petition, your lost is locus. Once the court takes cognizance of a public interest litigation, petitioner loses any sort of a control, including right to seek an adjournment, right? But we are granting you adjournment because it's a genuine cause. But you should be ready. Will you read Sheila Barse today, 88 Supreme Court? Go there and tell us at 2:30 that you have read the judgment. And what is it about? What is the citation and what have you read? What's your name? So 2:30. Don't disappear. We will this thing. We will keep track where you move and write. We have powers now. Don't like. Go to library just now and read Sheila Barse. Learned counsel for the petitioner.
May it please you not.
Yeah. Yes, Mr.
This writ appeal is filed seeking your lordship's indulgence where the learned single judge, in spite of these lands, are automatically exempted from the provisions of chapter 3. He passes an order that dismissing the writ petition. The facts of the case your lords may kindly consider that these petitioners are having an extent of 1 second. Less than the already exempted land of 20,000 excluding the roads and other things. Your lords may kindly consider that we have raised in the writ petition stating that this is an automatic exemption that is available. May I pass on this your lords, the judgments of this honorable court upheld in the Supreme Court. I have filed a compilation book for your lords kindly.
Ready, madam?
Yes, ma'am.
That's the appellants, compilation of citations. Nah. Madam. Wait. Connection. Okay. Okay, wait.
Correct.
Something incomplete, right? Page 3, sentence how it begins, requested. Thereafter, page 2 is there.
May it please your lordship. This land of 5 acres, 22 guntas, 20 guntas, your lordships, is automatically exempted as per the government orders issued in GOMS number 733. May I pass on?
No, when did you purchase the land?
Your lordships,
When did you purchase the land?
this was purchased by the
First of all, when GOMS was issued?
GOMS number was issued on 31/10/1988 and
3110.
88.
And when did you purchase?
No, my submission is when
When did you purchase?
it was under an agreement of sale, your lordships, it was purchased. One second. One second.
Prior to GOMS, right?
That is the 28th August 2000.
You purchased subsequently.
Subsequently. And your lordships may kindly consider
On?
through a special power of attorney.
No. What is the sale deed? Sale deed, when was the executed?
No, it was only under an agreement of sale, coupled with possession.
There's no transfer.
Yes, sir.
There is no transfer at all.
It's not the question of transfer, your lordship. Now the issue for your lordship's kind consideration is whether it can be termed as an excess land under the provisions of Urban Land Ceiling Act. When once it is automatically exempted from the provisions of Chapter 3 in the hands of my vendor, and the government orders are permitted to transfer. And your lords may kindly.
Who takes cognizance of that such agreement?
Yes, sir.
Who takes cognizance of such agreement if it is not transferred?
No, my submission is that your lordship is well aware. I am not on the issue. Though it is not transferred, this land which is held by me, possessed by me as a purchaser is automatically exempted from the provisions of Chapter 3. That's what I would like to.
On what basis? If it is not transferred, what are your rights?
No, not the question of rights, your lordship. The issue for your lordship's kind consideration is whether it is an excess land to be taken by the government under the provisions of Urban Land Ceiling or not. If it is not an excess land, if it is an exempted land from the provisions.
Agreement. What is the date of agreement in your favor?
It is at page number 69, your lordship.
No, date.
28th August 2000.
28.
Claims to be in possession by virtue of an agreement.
Agreement of sale come general power of attorney. And my submission for your lordship's kind consideration is this GO, whether it is a retrospective which has been issued invoking the statutory provision of the section 20 subclause 1A, this honorable court has held that the benefit of the exemption should be given from 17 to 1976. That was affirmed by the division bench of this honorable court and also Supreme Court in PS Rouse versus. So, the provisions of Chapter 3 are not applicable to this land. The learned single judge order, in spite of bringing to his knowledge, he doesn't take into consideration and simply rejects. Your lords may kindly. When once a land is exempted from the provisions of Chapter 3, Section 3 to 24 of the Urban Land Ceiling Act provisions have no application. That was held in Karnataka in Thakur versus.
No need. The provision itself, the exemption itself, we understand that much of law. The question is about your locus.
No, locus. Your lords may, my vendors if one. If in the hands, if your lordships may treat, if it is in the exempted land in the hands of my vendors, the benefit should also come, and it has been decided by this honorable court by a single judge affirmed by the division bench. May I bring it to your lordship's kind notice?
No, sir, but your vendors have already declared it. That your vendors have already declared that land.
Sir?
Your vendors have already declared that land as surplus land.
No, your lordship may. Your lordship may. The concept of declaration of a land, if it is a vacant land, if it is exempted land, the question of invoking the provisions from 3 to 24 doesn't arise. That was my contention before the learned single judge, which was ignored. I am also now contending before this honorable court. Now may I pray your lordship this. And this is excluding the roads and other areas. These two judgments, three judgments. May I bring it to our kind notice? This is an automatic exemption. There is no need of even application. That is the view taken by this honorable court in Nalla versus State of Andhra Pradesh. I need not, it is an automatic exemption, no need of any application.
So why did you come to the court then? If there is, your land is exempted, be happy.
No,
why have you filed the writ
Your lordship, if revenue officials and the state takes line to end and then trying to disturb my position, I have a remedy to approach this honorable court stating that the acts of the state are illegal, are contrary to law on the exempted land. Your lordship, may kindly see the UMS number 733, para 6, your lordship may kindly consider. Para 6. Now, therefore, in exercise of the powers conferred under Section 20, subclause 1A of the Urban Land Sealing and Regulation Act 1976, and of all other powers hereunto enabling and in suppression of all other orders issued previously in this behalf from time to time, the government of Andhra Pradesh hereby accord exemption of the vacant land or the agriculture land which is likely to be used for non-agriculture purpose of the option of the holder are both to a maximum extent of 5 acres situated within the peripheral area of Hyderabad urban agglomeration. 3 of the Schedule 1 of Hyderabad urban agglomeration and Warangal urban agglomeration, Vishakhapatnam, in excess of the ceiling limit from the provisions of Chapter 3 of this Act. Permission to transfer such land or part thereof by a person by way of sale, mortgage, gift, lease, or otherwise.
Your grievance is that they are interfering without any authority of law, right?
That is it. No, my submission for your.
No. So if the submission is that the exemption is automatic, then why seek a declaration from the court?
No, your lordship may kindly consider if
this is your argument that it is automatic exemption, provisions do not apply. And you claim to be in possession, we will say that they will not interfere with your possession except in accordance with law.
In view of the exemption that is available.
Why declaration? If there is an order of exemption in your favor,
that is not being.
You are not challenging this order here in the petition.
That order has been affirmed by this honorable court by a division bench.
You are not challenging this order. There is nothing. So then why seek a declaration from the court?
No,
madam, are you interfering? We will say that they can't interfere except in accordance with law. That's all.
No. Your lordship may also kindly consider whether this GO 733 and the law laid down by this honorable court upheld by the Supreme Court would be applicable to my facts and circumstances of the case.
So dispute is with regard to applicability, not simple. Not simple. You are saying automatic exemption.
That's what I have brought to your lordship's notice. If your lordship is pleased to consider, it is not automatic exemption. Your lordship may point out to me. That is an automatic exemption. And another GOMS number 289 dated 1/6. Your lordship may tell this is not one case. Several cases. Lakhs of acres because of my persuasion for 1600 square yards, right from a single judge to the Supreme Court. Supreme Court in PS Rao versus State of Andhra Pradesh has held that this exemption is available from Chapter 3, that is Section 3.
Correct, Mr. That doesn't, I mean, the provision itself says.
So that's what I am saying. If provision states, your lordship, if a citizen is having a grievance, They have the right.
No, you are arguing without telling us why your writ petition has been dismissed.
No.
That is the problem. You have to meet the grounds on which the petition, you are arguing as if it's a fresh case before us.
No,
There is an order against you. Why your petition has been dismissed, that you are not telling.
May I request your lordship, the impugned order of the learned single judge at page number 21.
Yes.
The petitioners are allegedly the owners and possessors of land advising 5 acres 20 quintas in survey number 32, 34 and 35 Kottapet village of Sarvanagar Mandal, Nandara district. After coming into force of the act, petitioners filed declaration under section 6 of the act, which was registered as CC so and so, and they were declared as surplus holders in Hyderabad urban agglomeration. A reading of paragraph.
Don't read it. You tell us what grounds it has been. You know it. You have read it.
The 733 benefit is not extended, which has been your last page number.
Why? Why it has not been extended? That is what we want. There must be grounds. 1, 2, 3, 4, 5. You tell us what grounds your petition has been dismissed.
Dismissed.
Otherwise, she will tell.
Dismissed for one.
If you don't tell, she will tell.
No, your lord.
Argue your own.
What I am trying to submit is.
So we have understood exemption is automatic and Supreme Court in V.S. Rao has held automatic.
That is there. Apart from that, your lordships, as I am a purchaser under an agreement of sale cum power of attorney, I am not entitled for that benefit. What the learned single judge had. May request your lordship, that has been decided by this honorable court and upheld by the division bench. May I bring it to your lordship's kind notice this. In 2017, 3 ALD 706, that's 51, 56, 59.
2017.
Your lord, may I pass on?
2017 3.
Yes, sir. And this is affirmed by the division bench. Nice. Dismissing the state appeal. Your lordship, the concerned paras I have brought to your lordship's kind note.
Para.
Paras I have noted for your lordship's kind consideration on to pencil your lordship's paras. And the top of your lordship's my kindly consider. Top of the radiation.
Which paragraph?
51, your lordship, 2 copies.
You don't have a copy. You please take.
I just mixed up. So many dates are there.
All the 3 copies you have given to us.
I'm sorry, your lord.
Yes.
May I request your lordship? Para 51, your lordship. May I read for my benefit, your lordship?
Yes.
A reading of the above government order indicates that the holders of the land up to 5 acres in peripheral area as specified to column number 3 to schedule 1 of the Act of Hyderabad urban agglomeration in excess of ceiling limit are exempted from the provisions of chapter 3 of the Act, and permission was given by the government to transfer such land to third parties also. And para 51, your lordship, in Nalla Yapu case, Supra, a learned single judge of this honorable court held that exemption contained in GOMS number 733 dated 31/10/88 is a general exemption, and it is not necessary to seek permission for exemption, provided 2 conditions: that the land is in the peripheral area and that it is of extent of 5 acres, exclusive of land set apart towards roads and open spaces, schools and hospitals are fulfilled. And I only request your lordship, the relevant discussion with regard to the appeal court. Para 61, your lordship, 59 also. Once the declarant is exempted, para 59, your lordship.
Sir, what is the extent of the subject land in the writ petition?
5 acres, 20 guntas.
So how this,
No, that is, that's why I have submitted another GOMS number 289. It is inclusive of 40% apart from this. What is the interpretation made by this honorable court, and para 51 also exclusive of the roads and other areas.
Sir, you should have given a synopsis. Nothing is there. Even the same issue was argued before the learned said that's a finding. Nothing
No, your
is
lordship,
out of your argument.
I only
When a question is
no, my submission is your lordships may kindly consider 5 acres plus 40% is 8.33 acres.
Where is it stated, sir? It is not.
You have permission for your lordships kind consideration, GOMS number 289. That has been discussed by the learned single judge, affirmed in the division para 51. Your lordships may kindly consider for a second, para 51. Of my this judgment, single judge judgment. Nalla Yakub's case, Supra, a learned single judge of this court held that the exemption contained in GOMS number 733 dated 31/10/88 is a general exemption. It is not necessary to seek permission for exemption, provided two conditions: that the land is in the peripheral area, that is an extent of 5 acres, exclusive of the land set apart towards roads, open spaces, schools and hospitals. That GO I have furnished the government order, GOMS number 289, dated 1/6. So 40% to be added for this 5 acres, 20,000 plus 40%. I think I have made it clear, your lordship. GOMS number 280.
It has not been filed before single judge, right? You are just passing on a copy like this.
Not that it has been, I have mentioned to your lordship in the single judge order, that was my submission made. Now my submission is, your lordship may kindly consider, the issue is whether the vendors in the hands of the vendors is exempted. If it is exempted in the hands of the vendor, automatically that benefit would come to the purchaser also. That's what the learned single judge has held in this decision, which I have now furnished for your lordship's kind concern, affirmed by the division bench. And it has become final. And your lords may also kindly consider para 59, your lordships, for a second, as the single judge order. Once the declarant is exempted, as your lordships got, 59, your lords.
So this judgment also applies to the agreement holders.
Everybody. No,
it says was given by government to transfer. There is no transfer in this case. That's repeatedly we are asking you.
No, my submit.
This judgment.
That's why I requested your lordships, para 59, your lords may kindly consider. Para 59. May I request your para 59, your lords?
Yes.
Also, once the declarant is exempted from the provisions of part 3 and is specifically permitted to sell the land in peripheral area of an extent of 5 acres as per GOMS number 733, dated 31/10/88, issued under GOMS number 20 of the Act by the government. The proceedings, if any, pending under the Act before the competent authority, so far as such land is concerned, ought to abate, since it is not disputed the exemption under 733 is automatic. And your lords may kindly consider the attention of the government that it was incumbent upon the part of the original declarant to challenge the subsequent proceedings under section 9, 10.1, 10.3 and 10.5 of the Act cannot be countenanced, because if such challenge is required, an exemption under GOMS number 733 dated 31/10/88 would not be automatic and would only be the discretion of the second respondent. Merely because the competent authority continued the proceedings against the declarant even after the GO came into effect, and even after the declarant sold the property, taking the benefit of the said GO without closing the proceedings under the Act as abated, he issued notification under section 10.3, 10.5 and conducted Panchanama, who is also, it cannot be said that such proceedings are valid in law. And to losses, in fact, after reading of GOMS number 733 dated 31/10/88, any declarant would feel that there is no need for him to bother about proceedings being continued against him in respect of the land in peripheral area below the extent of so and so, and that would automatically abate to expect the declarant to again challenge the continuation of the proceedings against him under, he availed the exemption under GOMS number 733 dated and sold the land as the land and government traders are to contend goes against the normal course of human conduct. For no man who has sold the land under the bona fide belief that he is exempted from the provisions of Act would bother to question proceedings still being continued against him after he ceased to be the owner thereof and had transferred sorry, Your Lord, to a third party. Nor will the purchaser bother about verifying about the pendency of the proceedings under the Act, since he would also feel that his vendor, having been exempted from the provisions of Chapter 3 of the Act by the GO, was competent to sell and proper title passed on to him, and proceedings under the Act pending against him, his vendor would abate. And this, Your Lord, is affirmed by the division bench, stating that I passed on for Your Lordship's kind consideration. The government has preferred a writ appeal that was dismissed by His Lordship's Chief Justice and Justice V. Ramasubramaniam, Your Lordship. I passed on for Your Lordship's kind consideration that judgment. I pass on the Supreme Court judgment in P.S. Rao's case. I have cited all those decisions and brought to the kind notice of the learned single judge. In spite of that, he has dismissed the writ petition. Your Lordship, page 22 of my relevant is para 4, Your Lordship.
Which judgment? Supreme Court or division?
Supreme Court, Your Lordship.
So division bench, you are not relying.
Division bench has affirmed the learned single judge view, stating that even the purchaser is entitled for this benefit.
Where which paragraph single judge has held that the subsequent purchaser is also entitled, and under an agreement the land can be transferred?
No, my submission for Your Lordship may kindly consider
this is what
that when once is exempted in the hands of my vendor.
No, where you please read which paragraphs.
51, Your Lordship.
51. Please read. It doesn't say that it is available to subsequent purchaser. Para 51.
Your Lordship may kindly consider page.
No, we have a specific query. Which paragraph of the judgment learned single judge has held that subsequent purchaser is also entitled?
Para 59, Your Lordship.
59. Yes.
Also, once the declarant is exempted from provisions of Part 3 and is specifically permitted to sell the land in the peripheral area to an extent of 5 acres for GOMS number 733 dated 31/10/88, issued under GO under section 20 of the Act by the government, the proceedings, if any, pending under the Act before the competent authority, in so far as such land is concerned, ought to abate. It ought to have been abated because my vendor is having an exemption. It is an automatic exemption. And we are in possession.
There is no proceeding against you, Mr. Under which authority has initiated any proceeding under the Act?
Your lordship is under the guise of.
No question of abatement.
No. Your lordship is under the guise of the earlier proceedings initiated under the Urban Land Sealing Act against my vendor. They are trying to take possession of the property, which made me to come to this honorable court and file this writ petition.
File a suit for injunction if they are taking possession.
No, my submission is, your lord, when it is a legal issue to be decided by your lordships. So he has been suffering almost 40 years. And can this honorable court will again subject the purchaser? Your lords make.
There is no proceeding. There is no proceeding initiated.
No, you're not
under the Urban Land Sealing Regulation.
Your lordships are.
You are seeking a Mr. Please understand, Mr. Rao. You are seeking a declaration that the order of exemption inures to your benefit, and therefore they should not interfere.
That is it.
This is the prayer.
If the law is very clear, if the law is very
That
clear,
we will decide.
no,
We will
my
decide.
submission, your lords may kindly consider. Let I have stated in my affidavit, which your lord.
Whether or not you are entitled to benefit of this exemption, that we will decide. That's learned single judge has decided. That we will have a look at it, whether learned single judge was correct.
No. My submission for your lordship, I have stated in my grounds, which are almost in a different context. The learned said single judge has taken a single judge orders, and yes, may I request your lordship, page 18 of my ground, your lordship. Government orders are also there, which your lordships may kindly get at. Either government has to.
Where are the grounds, sir?
Page
Your lordship.
12. Para 18. Grounds, I don't know whether he is like page 12. Yes.
Your lordship may kindly, page 18 is my relief that I have asked before the learned single judge. Appellant's land to an extent of 5 acres, excluding the roads area and the common area in the pending revision of the appellant in survey number 32, 34 and 35, part of Kottapet village, Sarunagar Mandal, Rangareddy district, in view of the government orders in GOMS number 1 and government memo number 18899 QC 2006-1 dated 27/2/2007, as the appellant land is exempted and outside the purview of the provisions of chapter 3 of the urban land sealing and pass such as order. May I request your lordship the government order which I filed. My submission is, your lordship may kindly consider whatever the benefit under law, citizen is having a right to avail. This
affirmation of your submission from outside. Yes. We have got it, Mr. You are claiming benefit of exemption notification. You are saying that once the benefit of, we have understood. I mean, don't repeat. It's a small issue. Don't repeat.
No, I'm not
Once you are saying
repeating.
that owner, if the owner is benefit to exemption, that exemption accrues to the subsequent purchaser also. Single judge has held it and it has been affirmed in division bench and there is a decision of Supreme Court in PS Rao.
That's I am only applying
and
for
therefore
that.
they don't have any right to interfere with your possession and property. That's
Much obliged.
right.
Much obliged.
Yes, madam.
My lord, the land is already vested in the state, my lord, by way of 10-3.
When?
My lord, I'll pass on my. One 383.
Yes.
My lord, after 11 years of the 1988 733 GO, my lord, they come to the court to challenge that. After 11 years, after 2 decades, my lord.
No, they are not challenging. They are relying on it.
That was on 31/10/88, my lord, GOMS number 733. And they are coming to the court after 2 decades of passing of the GOMS, my lord, even to challenge, without any explanation of why there is a delay to challenge.
No, no. They are,
Yes.
They are not challenging
They
GOMS.
are asking the benefit of 733 to be given, my lord. That is dated 31/10.
So WP has been filed after.
Yes.
When?
On 22/3/2007, the WP was filed.
Yes.
Then, my lord, this is he is claiming the land by way of agreement of sale after the land was vested with the government. So there is no legal right which was transferred, my lord. That was observed by the learned single judge. And then, my lord, this benefit of the 733 cannot be given to him because the land is already vested with the government. And as per section 19(1), my lord, when the land is already vested as per the ULC Act, no chat.
Urban.
This chapter will not apply to the certain vacant lands, my lord, as per 19(1).
Yes.
Chapter not to apply to certain vacant lands. One says, subject to the provisions of subsection 2, nothing in this chapter shall apply to any vacant land held by central government or the state government. So, my lord, my submission is, the land is already vested in the state government by way of 10(3). So, it is not a land which he can claim. It's already vested. The government has become the owner of the excess land. And that has also been observed by the learned single judge, my lord, in page 28 of the single judge's order. My lord, page 28 of the learned single judge's order, the last but one paragraph, my lord. Apart from explaining about 733, my lord, the learned judge has gone to say that by the time the GO was issued, may I be permitted to read, my lord?
Which page?
My lord, page 28, last paragraph.
Apart from above situation.
Yes, my lord. Apart from the above situation, another situation where the GO cannot be applicable would be the case on hand. By the time the GO was issued in October 1988, the land vested in the government and the proceedings under 10(6) of the Act to take possession was already issued. When the land is held by the state government by reason of section 19(1) of the Act has no application, and therefore the question of applying GOMS number 733 dated 31/10/88 does not arise. It must not be forgotten that GOMS 733 applies only for the land held by the individuals and not for the land which is exempted under section 19 of the Act. The petitioners herein already filed declarations and their holdings of the vacant land were already declared to be surplus land which is vested in the government. Therefore, the petitioners could not have sold the land in year 2000 to so and so and 4 others. Such void and speculative sale do not confer any right to seek remedy under Article 226 of the Constitution of India.
The exemption had to be questioned was given in 93. Transfer 83 had vested in the government. She has told the 1983 vested free from all so once the vesting is done, state Yes,
No,
Mr.
my submission to Lords is this honorable court affirmed by division bench and the Supreme Court that the GO exemption is applicable from 17 to 1976. That exemption of 733, if it is available to the landholder as well as the purchaser from 17 to 1976, the provisions of chapter 3 to 24 would not apply, your lords. And that is the settled law, as your lords is well aware, in 1996 in Tandur versus State of Karnataka, where the issue is whether the government is having a power to exempt or not. The Honorable Supreme Court has said when once the government issues an exemption, it restricts, it wipes out all the restrictions, including the transfer. 1996, if your lords I have compiled and filed 1996, Supreme Court, your lords. T.R. Tandur versus State of Karnataka.
What is the citation? 60?
1996, Supreme Court, your lord. If your lordship permits, in the lunch period, I will procure and pass on for your lordship's kind consideration. No, the issue is AR Six, Supreme Court, your lordship.
1996 Supreme Court.
Yeah. Your lordship, AR 1996 Supreme Court, page number 1643, equivalent to 1996 SEC 3690. In the last operative portion, what the Honorable Supreme Court has observed, any restriction with regard to transfer will also be wiped out in view of the exemption. That's what is the sum and substance of this. And that has been followed in various nations and all the.
One 96 Supreme Court.
No, my submission is, your lordship, whether the proceedings under the act can be initiated right from 3 to 24 is an issue which your lordship may claim. And once it is exempted from chapter 3 of the provisions of the act, section 10 is not applicable, section 6 to 10. Even acquisition 11, compensation and all would not apply, your lordship. That's what is the sum and substance of my submission for your lordship's kind consideration.
Madam, one thing only, one query for you. If the land was already vested, why did you this thing exempt it? It was before issuance of exemption notification, it was already vested.
It's already vested, madam.
Then why did you issue this notification?
Notification
Exemption notification in 88.
88.
Why?
My lord, it's not for particularly this land, my lord. Others in peripheral area where they were having more than 5 acres extent.
Ah, fine. Generally. Yes, Mr.
Much obliged.
All right. Thank you. Yes, madam.
I pass on your lordship. Judgment, it is there. It's 1996 is there, your lordship. I just pass on for it. Last but 2 paragraphs, your lordship.
Given. अच्छा give.
Conclusion paragraphs, your lordship.
Restriction.
Conclusion paragraphs, last page.
Ah, yes.
Much obliged.
All right. Shall you will dictate. No, no. Yes, in this intra-court appeal is fine.
Position is not there. In Anram's case, that is abated. That's one submission. In PS Rao's case, even after vesting also, this exemption is available. Your lords may kindly consider PS Rao's case, after exempt.
One paragraph. Give that.
I did 20,000 square meters, your lords. Not 10,000 square meters.
Mister, we are reading what you have given us. It says 10,000.
Your lordship.
We have passed an order. Some grounds for SLP also, right?
No, not that your lords may.
Right.
If a litigant having waited for 40 years gets an adverse order, your lords may kindly see the agony of a landowner. Now, my submission is, your lords, after 3 provisions.
We have heard you, Mr. Rao. You cannot argue afresh.
Your lordship
You cannot argue afresh, right? We have heard
not that P.S. Rao's case where the after exemption, if the land is vested with the government also, it would apply. May I request your lords may kindly consider.
No. We have considered whatever.
No, your lords may kindly consider that because it is.
What is this, Mr. Rao? This is not fair to the court. That after our judgment is being dictated, you are arguing that
Your lords may kindly consider that the version of the government cannot override the judgments of the Supreme Court Ketina of decisions, 1996 onwards till today. And we are governed by the decisions of the Supreme Court and the statute. 733 is to be applied from 17 to 1976. Even the so-called vesting of this land, of exempted land, is it will be an illegal and unlawful act, your lordship.
Fine.
So,
one paragraph, right? So.
Position is with the writ appellant. So the proceedings against this land shall also abate. As your lordship, para 42 of the Hariram judgment clearly says, if the physical and actual position is taken, it will not rest with the government.
Yes.
Your lords may kindly observe that also, so that whatever the grounds that I have, I must be in a position to satisfy myself and satisfy the Hariram. Your lords may kindly, Hariram versus para 42, your lords, I am in physical and actual position. All the proceedings earlier issued are abated. To that extent, your lords may kindly observe.
See the prayer clause. You have read it. This is not the prayer in the petition.
No.
You are asking us something. File a fresh petition. If you are so advised. We have not said anything who is in possession. Please.
No, but that the agreement of sale comes.
All right, Mr. Rao. There some things must come to an end.
No, not that. Something your lords may kindly consider. When once an issue is there, it has to be. It is our duty to persuade your lordships and to convince your lordships about the legality of an issue.
Call list, right? Call list.
And your lords may kindly observe that we are in actual that submission. Your lords may kindly consider. Otherwise, your lords may kindly call for the file whether they have taken position or not. Simply saying government time and again every time circulates a note without there being Where is the evidence to that effect that they have taken position under section 10(6)? Without that, your lordship, if anything is citizens have to be given necessary credence or audience than the government. Government every time says it is a land vested with the government. What is the purpose of exempting the land and then say after time this is vested with the government? So my submission is your lordship may kindly observe that the appellants are in actual and physical possession from 2000 onwards.
This thing, madam, his submissions also you record why it is submitted that he is in possession, actual physical. Forty-seven. Yes.
I appear for this matter, your lordship.
Ah. Oh. So, Mr. Rao, some other day, next week.
Since 40 years,
No, next week.
Your lordship may kindly, compensation has not been paid. I think your lordship may kindly consider, it's not
Which
my
case?
agony.
47.
47.
Ah.
They have acquired the land in
What is
1972.
1 minute?
So far compensation has not been paid.
1 minute. There is a condone delay petition amendment implete. What is this? What are these petitions?
And
Condone delay. What is condone delay?
condone delay in preferring the writ appeal.
Ah, that all right. Yes, what do you say, madam? We will condone the delay. Heard on IA.
Purchaser through the vendor. And now he is.
You are opposing this prayer.
Yes.
To file counter.
Very well.
Learn it.
Much obliged.
My lords, with your permission, I appear for the appellants in 48 years. On the last occasion, I've submitted that there is a scope of compromise in the matter. However, the learned other side.
No, it will not be adjourned, madam.
My lords, however, the learned other side had denied to that extent.
You
Their
please argue.
suggestive-
If you don't want to argue, we will help ourselves, right?
My lords,
Fine.
their suggestive is
No.
that if I withdraw the writ appeal, that should suffice to an end of a compromise. However, pending contempt, I see it an impediment, your lords. This is a writ appeal that I filed against order of the writ
No, we will
petition.
dispose of that contempt petition, if you want to withdraw. What is the contempt? What have you done? Nobody is appearing for respondent, madam, please argue. Then what do you say?
Order that is operating. They have expected salary to your rate, what is the authority? But in spite of that, what they are executed the savings in favor of third parties. They have not subsisted interest, that is why they want to withdraw. And the part whatever the content penal action that has to be taken.
That will take.
Cannot be paid by them. They have to go. Not the principle of springs. Timber versus street.
Yes, madam.
My lords, this is not a case where sale deeds have to be set aside without any intention to punish the respondents. Here, the contender has clearly filed an application to that extent. My lords, my humble submission is that.
Madam, writ appeal is listed. So you please argue. What do you want to do? You want to withdraw the writ appeal?
My lords, if I withdraw the contempt, stand in case, your lords.
Madam, it is not for us to suggest what you should do. If you withdraw, what will happen? You argue, please.
Very well.
The only thing is no adjournment will be granted once it has been adjourned. At your instance, this is 2008 matter. Please.
Very well.
Fine, please argue whatever. Otherwise, we will help ourselves. Thank you. If you
to avoid any penalty staring in the face of the appellants, I have to argue, your lords.
So please argue. We are not saying not to argue. Please argue.
The writ appeal is filed against the order dated 3/11/2008 in a writ petition 8381 of 2005, your lords. The petitioners are the appellants in the matter. We filed a writ appeal questioning the maintainability of the appeals before the RDO, stating the same to be contrary of Section 8, Subclause 2 of Telangana Rights in Land Pattadar Passbooks Act 1971.
Yes.
We've also gone to state that R4 has attended a case before an authority that is wrongfully constituted. Therefore, we have sought for a prayer of call for records relating to the order and judgment dated 3/11/2008 in the writ petition to be set aside, and thus the orders be suspended, your lords. That is the prayer of the writ appeal. My lords may see page 71. Page 71 are the revisional orders of the Joint Collector Rangareddy district. The case we've put forth is that we are the owners and possessors of the land in question, and as such, they were issued Pattadar passbooks and title deeds in respect of lands in question. The RDO officer, East Division, on an application submitted by the respondent number 1 and others called for a report from the MRO Kutubullapur Mandal. The MRO, through his proceedings, A/1730/2000 dated 28/3/2000 reported that earlier Mandal Revenue Officer on the report of MRI sanctioned succession of land in question in favor of the petitioners within a separate proceedings A/3671/1998 dated 13/1/1999. Despite filing objection petition by the R1 and others stating that they have purchased the plots and survey numbers 286 of Gajulam Ramaram village from the original owners and enclose necessary supportive documents. However, based on the orders of the MRO, the Pattadar passbooks and title deeds were prepared and issued to the petitioners herein, and the report was concluded with a request to take action for cancellation of Pattadar passbooks.
Madam, what are you reading?
My lords, I am reading the order that goes against the petitioners.
Supposed to read the order, you have to make submissions.
My lords, I am
Of
coming
this
to
order.
that. I am coming to that, your lords. My lords, conclusively, this revision was dismissed, your lords, stating to say that it is not
We
maintained.
start with saying what is your case, how your issue has been considered, and how you are aggrieved with the order of the learned. You have to start in that way. Just going on reading the order, it's neither here nor there.
My lords.
You at least give a synopsis. Nothing is there.
Very well, your lords. My
No. Seek adjournment. Will not do that.
My lords, my submission is that I filed a writ stating to say that the orders of the RDO and the revision thereto are touching the rights of the respondent, whereas they were supposed to approach a civil court, and therefore the appeal under Section 8(2) of the Telangana Rights in Land Pattadar Passbook Act, the old act, is not sustained, your lords. That is the case I have made out. However, they went ahead to entertain a separate revision as well in the said case, against which I filed a writ petition, and the writ petition is now disposed of, stating to say that there's nothing to touch upon on the orders of the joint collector or that of the orders of the RDO, your lords, which is why I filed a writ appeal. I've well quoted the grounds to suggest my case before this honorable court. However, they don't want to drop any plenary action through the contempt case they have filed. Once I withdraw the writ appeal, there is no question of a contempt arising out of the status quo that was granted earlier by this honorable court.
Yes, good. That's all.
I suggest that the merits be entertained only when the contempt doesn't survive, your lords. Otherwise, I'll be put to harm in the said appeal.
Madam, appeal is listed for hearing. Please argue. Put to harm means we will also be put to harm if we are required to write an order. Like we will have to strain our throat. What is this argument, right? Put to harm, please argue your writ appeal, whatever contempt, we will deal with it. We are asking you to argue, that's all. Please argue. We'll take you this thing. We will take after the break at 2:30, right?
Very well.
Please you go through it.
Very
Whatever. You have to you have to tell the facts first and then this thing, why did you file a writ petition and what happened? What has learned single judge held? Why those findings are incorrect? That's it.
Very well.
That's what it is.
cancellation admissions, regarding PhD admissions pertaining to Dravidian University, Kuppam, Chittoor district, belong to Andhra Pradesh. All connected matters are transferred there. Only one matter is here, my lord.
Item number 74. Learned counsel for the petitioners. Yes, please. Yes, madam.
My lords, with your kind permission, my
Yes, ma'am.
I'm stating the facts to the court, Your Lord.
Yes.
The petitioners claim that they have succeeded to acres 311 guntas of land in survey number 286 of Gajula Ramaram village, Kutubullapur Mandal, Rangareddy district. They claim to say that they have succeeded to the lands from the original owners. However, it is the case of the respondent number 4, that is the housing society, that they have purchased the properties by way of a sale deed executed by the GPA holder of the late original Pattadar. My lords, it is nowhere disputed that there is no succession order. However, the availability of it is questioned in the quasi-judicial proceedings. These succession orders are also passed by the respondent number 3, Your Lords. The Pattadar passbooks and title deeds are issued in favor of the petition. Subsequently, upon a representation and considering the representation itself to be a matter of an appeal, the quasi-judicial authorities went ahead and they have decided to say that the Pattadar passbooks issued in favor of the petitioners must be cancelled. When we filed for a revision before the joint collector, they've stated to say that the revision is not maintainable. Against this, I have preferred a writ petition, and the writ petition number is 8381 of 2005 before the Honorable High Court. In the writ petition's order dated 3/11/2008, the court has clearly stated that they find no reason to interfere in the orders of the quasi-judicial authorities when examining the validity of the orders. Now, against the same, I have filed a writ appeal before the Honorable High Court with a prayer calling for records in relation to the judgment and order copy and seeking for set aside and suspension of the same. For the same, I have raised several grounds, Your Lord. One of the grounds is also a limitation.
Why your petition has been dismissed, madam?
My lords, I may be allowed to point out the order copy. My lords may see the order copy on page 19. The learned judge writes to say that in my considered view, the documents produced before the respondent number 2 were sufficient to drive him to the conclusion that it has ceased to be an agricultural land. If the petitioner seriously dispute the validity of registered sale deeds, it is not possible for respondent number 2 to give a finding thereon. The only remedy which is available to the petitioners is to file a civil suit under the Specific Relief Act 1963 for declaration of their title. If any relief is granted in such a suit in favor of the petitioners, they can assert their title and make fresh application for amendment of record of rights and issuance of Pattadar passbook under sections 4 and 6A of the Act respectively. For limited purpose of examining the validity or otherwise of the order of the respondent number 2, I am of the view that the order passed by the respondent number 2 as confirmed by the respondent number 1 did not suffer from any illegality warranting interference of this court under 226 of the Constitution of India. Considering this operatable portion, I have filed my writ appeal, Your Lord, on the following grounds. One, to say that
No, the first and foremost ground is whether you are to demonstrate that the land is an agricultural land. Until unless the learned single judge, why you have just now read? The learned single judge has held that it is not an agricultural land, therefore provisions of the act do not apply.
My lord, those were one of the points of consideration that arose even before the learned single judge in the writ petition. Conclusively, they have claimed to say that it does not remain an agricultural land because there is a issue of scheduled plots that are being laid in favor of the society. Even today, the society is largely in possession of all the scheduled plots.
Agricultural land.
Even GP executed by the petitioners was not issued till now.
Ask her. Yes, madam.
My lords, even today, the society is largely in holding and possession of most of the scheduled plots. Nowhere they have claimed to say that they are in possession or they are the right holders in the land.
The land has already been converted to plots.
My lords, now that our Pattadar passbooks are cancelled long so before the quasi-judicial authority and our revision was held not maintainable. Only by the satisfaction of the Honorable High Court, there was a status quo order. They've claimed some position and grounding in the same scheduled lands. Otherwise, there is no question of fresh vesting with the society as on today, your lords. There is nothing in the hands of the writ appellants today. It could have been scheduled plots even when there was a pending writ petition. However, their Pattadar passbooks and holdings to that extent were cancelled. Therefore, they've sought for a revision before the joint collector. My ground is that the very authority must not have looked the representation itself as an appeal. And that there is also a question under section 8(2) of rights in land, Telangana rights in land Pattadar passbook.
Madam, what is the locus standi of the petitioners? Admittedly, the predecessor has sold the lands through the GPA, which has not been questioned by the petitioner anywhere.
My lords, our locus standi is the succession order, which was also set aside.
No, it was given by oversight. What you could have questioned the very sale deed entered by the predecessors. You have not questioned the very sale deed.
My lords, this is a case where more than 33 plot owners have claimed to state so. All of them have a different sale deed, all of them have different flow of
Without
height.
questioning those, how can you get a succession certificate? So it was rightly dismissed.
My lords, we were only seeking quash of a quasi-judicial order. However, our rights were to be fought even in the...
This court wants to know what efforts have been taken by the petitioner. If they are aggrieved with the orders of that, they should have taken proper steps at the initial stage. We don't know whether the money has been transferred and they might have utilized it. It could be a afterthought process.
My lords, most of it is unrevealed before this honorable court, your lord. For the reasons that even from the quasi-judicial orders, if we observe, nowhere they say that they have purchased the land as from the original Pattadars. On the contrary, they only submit that they have succeeded to those lands by way of a succession order. And such succession order is not found in the revenue records is what they have claimed. Without even being found or without even having to contradict or submit in the contraventions, they have simply set aside the succession orders and cancelled the Pattadar passbook.
That's all.
In fact, one of the questions that the learned single judge had also considered is whether an appeal lies against the order passed by the respondent number 3 in favor of the petitioners, your lord.
Yes, madam, go ahead, make your submissions.
My lords, the other ground is only subject to the reading of section 8 subclause 2 of the act, which necessitates that the person aggrieved by an amendment in the revenue records under the act is to approach a civil court, and therefore the very maintainability of the appeal before the respondent number 2 is contrary to the provisions contained in section 8 of the Act, and the same was held by the Honorable Court in a reported decision as well, my lords. I have stated it so in the grounds. 2000 ALT REV 38, which is still holding the field and is relied on and followed in a canton of decisions. Though having noticed the said judgment, the respondent number 1 as well as the respondent number 2 misguided themselves and carried the learned single judge still further.
What is the contempt petition about?
Contempt application is quite low because they have executed documents alienating the property again, having already sold by way of plots. They were also parties to the GPA along with the.
When was the order passed? Ah.
Papers. The order passed by some report in the 140.
Order dated? Simple, right? Ah.
December 2008 at
Ah.
page 140.
What does the order say?
The order says that all through the during the pendency of the retention orders of status quo were imposed. Therefore, status quo obtained as on duration between further orders. There has been status quo pending the writ petition as well as pending the return.
When they have sold the property?
Pardon?
When they have sold?
Yes. But they have sold, they have executed, they went on executing say, the documents, which I have not made a table. The tests of my application, patent application. Paragraph 5, there is a table. 527 of 2007 dated 30. Document number 527 of 2007 dated 13/10/2007. That is the registered AGPA.
13/10/2007. So this is before.
That's not the only thing. They have executed.
No, 6/12 to after 6/12/2008. You tell us
Yes,
which.
that is document number 5107 of 2010 dated 21/6/2010.
21/6/2010.
21/6/2010. Another is 851 of 2011 dated 27/1/2011 and 698 of 2011 dated 22/1/2011.
All right.
Three documents.
Yes. So they should be punished.
I am not, that is for your lordships. One, my only limited prayer is the contemner cannot take benefit of the resolve in the violation. Let these orders, let these documents which were taken.
So this relief, I mean, can be granted in a contempt petition. That's what we would like to know
Yes,
from
yes.
you.
That is, I am relying on
Ah.
justice, even in 1996, volume 4, SCC 622.
1996.
Volume 4,
Ah.
SCC 622,
Ah.
whereas 17 to 21. This is the Delhi Development Authority versus Skipper Construction Company Limited. But their lordships have framed the question like this: the contemptor should not be allowed to enjoy or retain the proofs of his contempt. The principle that a contemptor ought not to be permitted to enjoy or keep the proofs of his contempt is well settled. In Muhammad Idris versus Rustum Jahangir Babuji, this court clearly held that undergoing the punishment for the contempt does not mean that the court is not entitled to give appropriate directions for remedying and rectifying the things done in violation of its orders. The petitioners therein had given an undertaking to the Bombay High Court. They acted in breach of it. A learned single judge held them guilty of contempt and imposed a sentence of 1 month's imprisonment. In addition thereto, the learned single judge made appropriate directions to remedy the breach of undertaking. It was contended before this court that the learned judge was not justified in giving the aforesaid directions in addition to punishing petitioners for contempt.
This is the prayer is this thing. Other paragraphs we have read it. This is for restoration of possession, like in para 19, right? 20.
Whether it is possession, or other benefit which they have derived, they what I
No, what like sale consideration should be deposited. That's what the benefit they have derived is.
But they have already sold to us by way of plots. Subsequently, they went to the Tahsildar and obtained succession. That succession file is missing. That is the report of the subsequent Tahsildar.
No, we are on the please we are on the issue of whether the sale deeds can be set aside. You are seeking that relief. It should be. That is what we are trying to ascertain.
Yes.
Whether sale deeds can be set aside in executed in favor of some persons who are not even party before us, right?
The purchasers pendente lights will not have no rights. They have even not entitled even for a notice. But they have taken the risk and will not the consequences will follow because 52 will come into operation. They are void. So under void document they cannot claim any rights. But these documents were not registered in spite of the status quo. Otherwise, in spite of this, I will be driven to again civil court. In fact, they filed a suit for injunction. They lost the IA against me. Then they withdrew that, they abandoned that suit and then went to the Tahsildar. That is the conduct. And at every stage, their conduct is blameworthy. And they executed 2007 ADPA.
So this is the judgment. Any other one?
The judgment will come.
All. Yes, madam. What do you say in contempt? So it is clearly a violation. Huh?
My lords,
Huh?
my submission to that extent is very limited, your lords. My lords may see the counter I have filed.
No. What is the submission? You have sold. You have executed these sale deeds.
On the the ground I have taken in writing is that on the similar ground, the respondents filed for a vacate stay, your lords, and the same was dismissed. And therefore, the subsequent to that, they have preferred this contempt case. My lords, as on today, there is no piece of plot that is in the hands of the appellants, even to deliver possession. Not because they have went ahead to conduct a sale of the property pending the case.
No, madam. This details have been given in para 5 of this contempt case.
My lords.
The details of documents executed by you. Is it correct that you have executed these documents?
I have no instruction to that extent, your lord.
No, how can you, madam, no instruction?
My lord.
You can say that I have no instructions to argue the case also. I don't know who is there. Like this, can this be argued?
My lords, to these specific documents, I was not informed that when they are
Not informed, you have filed, please, madam, you have filed counter to this.
The only suitable response we filed was that the similar grounds were taken for a vacate stay and it was dismissed. And we have not been in straight violation. There is no
How does it vacate petition? You wanted vacation of stay. That petition has been dismissed. How does that help you in a contempt case?
They prefer the counts.
So how does it help you in a contempt case?
Our case is that we have
A stay was not vacated. You filed an application seeking vacation of stay. That was rejected. and the stay order was made absolute. Despite that, you have sold the land. Fine. Anything else?
My lords, the only submission is that the grievance here is in continuity, your lords. We are not in possession of our lands even to deliver, even to enter into a registered sale deed. There could have been a case where had my right stayed alive, it would have been a very valid.
What is, according to you, madam, what is the issue in the contempt petition?
My lords, my humble submission.
What is the issue? We are submission, forget. What according to you court decides in a contempt petition? Please tell us. Forget about this case.
Whether it must materialize on the whole as a contempt or not.
Materialize? Whether an order, whether you have violated an order of the court, right? The question is that there was an order grant on 6/12/2008 granting status quo, and you have executed sale deeds thereafter. So what can be done? It's not your case that I was not aware about the order. You knew that an order of status quo is there. You filed an application seeking vacation of stay. That was rejected. Despite that, you went ahead and executed sale deeds. What else? I mean, we don't know.
I know not all the appellants were amenable to the same succession order, your lords. That is the only plea I can take. Whereas now that I do not have any rights or
No, they have given respondents 1 to 4 and 5 have this thing 1 to 3, 4 and 5. Everybody has executed, madam.
They've written to state so, your lords. However, in our counters also we've undertaken to say that they have not violated any interim orders and that they are not very well educated to comprehend the needs.
So, this thing on this principle, say it's was executed in matter of violation and the conduct is very peaceful, willful disobedience. We reserve it. Willful disobedience and therefore that to be punished. We have to criminal a response but principle. That's all, madam.
My lords, one more submission is that the status quo granted in respect to the said property was with regard to the mutation of names in the records and dispossessing the petitioner from the property. That alone must be considered.
What is the prayer in the made in the this thing? That is the ground. Yes. Now you what was the prayer made in the application for a stay? Yes, mister. What was the prayer in the application for a stay? Huh?
Prayer is suspend the order of the delegates. But what I did submit is the status quo order was granted without specifying order. So
then
it applied for
the status quo is I mean, as vague as it can be, like a status quo with regard to, see, mister, when the court simply says status quo, the settled rule is it has to be read in the context of the prayer made in the petition. There you may be correct. So, status quo means what? Status quo means the order of the single judge remains to be operative. That is the status quo in the context of prayer. Huh? Prayer was to stay.
order.
No, not writ appeal. We are concerned with this order 6/12/2. This was passed on IA. Which IA? And what was the prayer? The order of status quo will have to be read in the context of the prayer made in IA. Huh?
At that time,
So what is the prayer?
Prayer is to suspend please to suspend the operation of the order of judgment dated 3/11/2008 passed in the London Civil Date of 2004, WP number 83.
So what does status quo mean? What would you tell your client? What does status quo means?
Status quo means that we will have to maintain status quo in all respects unless the court specifies with regard to possession or with regard
But this is also we are putting a query to you. This is also a legal position where the I mean an order, interim order has to be read in the context of a prayer made on an application, in the application.
they are looking at. Permit me, I will place it. But my lords,
What did
what exactly what means status quo whether this has to be.
you give it by tomorrow?
My lords, I may be
Today.
permitted to read the exact words in the order, your lords.
Yes.
The court made the following order, heard both sides. All through during the pendency of the writ petition, the orders of status quo were enforced. Therefore, status quo obtaining as on today shall be maintained until further orders.
So
My lords may see page 5, the status quo orders
that
are
madam,
of
you
the
understand, right? This is understand that the status quo was in respect of subject matter of the
in respect to the subject matter, your lords.
What the status quo will not to change the physical features. It is always with condition. What is the
One last submission, your My lords, here the only question is whether the learned single judge's order must be set aside or suspended or not. However, your lords, the question as to whether the sale deeds that we have entered, two sale deeds are of the year 2007, your lords, they are prior to the status quo order. For the other sale deeds, we claim to say that they were subsequent alienations. If I'm allowed to peruse my counter copy, I will assist on that furthermore. However, your lords, my submission is that through the contempt, we need not examine the recourse of having to cancel the sale deeds that were illegally entered, if any they were in the matter.
He has given this judgment, right? Skipper construction.
My lords, through that I am amenable to penalty as well, your lords.
Yes. Anything else? No, you can't pursue anything, right? It's once the contempt is between the complainant and the court, we have to decide. You can't say that I don't want, so I will not. You cannot. This, it is, you don't have any say. We will have to deal with her. Yes. Anything else, madam?
That is all, your lords.
All right. Thank you.
I'm
Right.
obliged, your lords.
Why not? You should have given it in the beginning when she was struggling to state the facts. Yes. But you should say so, right? Huh? Waiting the case to be called, huh? As if it will like FD will give multiply the cases for you. Nothing of that sort. You could have told though in the beginning itself. 50 learned counsel for the. Yes. Ah. Yes. Obviously, I mean, he is not appearing. That means there is nothing. Huh? Yes. Huh? Issue direction mandamus declaring not prevent. What interim direction? Huh? What is this PIL? What do you say in the counter?
I appealed to the fourth respondent temple Malata. There was no encroachment or Malata obstructed the Malata temple in violation of any Malata. The temple was Malata existing for therefore Malata.
Oh, see, petitioner is trying to protect your land and you say that there is no encroachment. Huh?
Complaint is that Malata temple encroaching that Malata the road
Ah,
and
oh.
constructing that one. But temple context.
So where is your counter?
Malata, I filed Malata by way of record stand counter.
Fine. Yes, well versed. Answering respondent has already filed. Petitioner is not a public spirited individual. How do you know?
Last में time see Malata is Malata.
Huh?
The paper Malata and also Malata is the one Malata who includes the public road.
Not printed. Encroacher is a public road. Huh? Huh?
They are not encroaching.
All right. Yes, madam. Right. In this petition. Yeah, dismissed, you say, madam. Dismissed, same is according. Ah, yes. What is it, madam?
Writ petition is filed. And,
Yes.
seeking declaration of functioning of DRT to be under the control of Ministry of Law and Justice instead of Ministry of Finance. It is filed in 2010, my lord. My lord, I request your lordship to kindly grant me some time. A formal counter will file, my lord, because they say that in view of the judgment of the Supreme Court, this administrative powers of the DRT should be transferred to Ministry of Law instead of Ministry of Finance, my lord. They say that the conditions, I mean, contrary to the Supreme Court judgment, they are still working under the Ministry of Finance. My lord, the judgment of
2010 volume 4.
My lord, your lordship may kindly take to page 13. The judgment, my lord, it starts at page number 13. The relevant portion.
30.
13, my lord. 13. Where, my lord, the NCLT and other things, I mean, NCLT that has been transferred under the control of Ministry of Law, as they say that one member should be a judicial member rather than being a tribunal, it should have judicial member. Your lordship may kindly take the relevant portion, my lord. I request your lordship to
This
kindly
is the
take.
case on which petitioner is placing reliance.
Yes, my lord.
Union of India versus. No, there's some other case, madam.
My lord, the judgment, my lord, 11/5/2010. It's an.
No, 2010 volume 4 Supreme, same judgment.
Right. I'll verify, my lord, because just now I've collected the papers, my lord. I did not have the bundle. My lord, it's some time, my lord.
No, madam.
At
After 13 years, I mean, you shouldn't ask any time.
My lord, I mean, the judgment, my lord, this is of the civil appeal 2004, my lord. It is decided
So
in
it can't be-
2010. 11th May 2010, 98 page number. The judgment which I'm referring to of page number 13, that is decided of 2010. I think it may be the same judgment, my lord. I'll.
Find out, madam.
Yes, my lord.
When it has been decided.
My lord, page number 90, 98, my lord. The date of judgment, 11th May 2010.
11th May 2010. So 2010 SCC, you find out, madam. Union of India versus R. Gandhi, President Madras Bar Association.
My lord, in that particular case, my lord, which is referred at page number 13, which runs to 98 pages, my lord, where the writ petition was challenged by the Madras Bar Association stating that the constitutional validity of chapter 1B and 1C of the Companies Act, where, my lord, NCLT and NCLAT, they were under the control of Ministry of Finance. As per the judgment, my lord, which is referred at page number 13, that is transferred to Ministry of Law, my lord. Your lordship may kindly take to relevant portion, my lord, at page number 96 onwards. 94, my lord.
No, are you appearing for the petitioner?
I am appearing for respondent, my lord.
Then?
1 to 3. I said, my lord, 1 to 3. Because the petitioner for counsel, because I appear for the DSG office, my lord. This matter is allotted to me. So I am
Whatever, we know that you are appearing for respondents, but you are arguing as if You are appearing for the petitioner. That's why we are asking.
Well, that is the contention of the petitioner, my lord, I mean to say.
Ah.
I have to tell the facts, my lord, so
Yes.
I'm only,
Yes, yes.
I'm only assisting.
So what is your answer then? Contention is fine.
My lord, that is transferring from one particular ministry to other, my lord, it is a legislative, my lord. My lord, I will file a formal counter, my lord.
No, nothing. 13 years you did not file. There is no question of filing counter after 13 years.
My lord, at least tomorrow, my lord, I will
Sorry.
at least go through the bundle and come
We
back.
will not. No, you should have gone through. The case is taken up at 3:20. You had the whole like lunch hour to your disposal. Before that 3 hours, what did you? I mean, when the case is called, only then you will tell the court that I will go through the bundle. People wait even to withdraw the writ petition till it is called. I am surprised that we are told that nothing survives only when the case is called. They will not say out of turn. So same like feeling inspired by them. So who is the petitioner? Medicare International Limited. None for the petitioner. Right.
I beg to appear on behalf of the petitioners, Your Lordship. The
Yes.
present writ petition is filed challenging the action of respondents in insisting of a NOC under AP Agricultural Land Conversion for Non-Agricultural Purposes Act, Your Lordship. An interim order was passed in this petition, Your Lordship. Subsequently, a writ petition on a similar question was decided by this honorable court, Your Lordship. May I just pass on the same, Your Lordship?
Covered, right?
Yes, Your Lordship.
Oh. Yes, madam. In this writ petition, the petitioner has prayed for the same. 54 is also same.
Yes, my lord, I'm for the petitioner, my lord.
Same.
It's the same matter, it pertains to the same issue. Apologies.
Hmm.
Please, Your Lordship. I'm for the appellant's, yes, and then, counsel for the writ petitioner respondent G. Dharmarao is no more, my lord. I want to bring it to the notice of the court. Counsel for the respondents writ petitioners G. Dharmarao is no more, my lord. That's what I want to bring it to.
So you are appearing, right, madam?
I don't know who is appearing in that. I'm for the appellant. I am for the appellants.
So appellant means it's your appeal, right?
Yes, my lord.
So then you have to argue.
Yes, my lord. I'm bringing to your lordship's notice that respondent advocate G. Dharmarao is no more, my lord. He is the counsel for the writ petitioners. Respondent in the present appeal.
What, like notice has to be issued?
Since it is your appeal, you go ahead, man.
Yes,
They have to make their arrangements.
I'll leave it to your lordship.
Counsel for appeal. Respondent is who? No, which respondent? Respondents 1 to 3.
First, only one writ petitioner, my lord.
No.
Respondent.
Which
Yes, 1 minute.
respondent, madam?
Yes,
Mark her presence. It is stated at the bar that
first
counsel
respondent.
respondent.
Yes, my lord.
Huh?
They are the respondents in the writ petition, my lord.
No, you are saying respondent number 1. That's why we are confused.
Respondent in the appeal.
Only one respondent. And 2 and petitioners number 2 and 3 have not preferred an appeal.
I'm subject to correction, my lord. Writ petitioner is 1 and there are 4 respondents in the writ petition.
1 minute. Sorry. This is Mr. 55 onwards, not scanned. Oh. Sorry, we were looking at the, which is not here. Respond number. It is stated at the bar that counsel for respond number 1 has
It is 55 law.
Lord, I appear on behalf of respondents 5 to 11.
My lords, appearing on behalf of the appellants, my lords. My lords, this writ appeal is preferred against the order of this honorable court, my lords, of the learned single judge, which is available on page number 20. The order under challenge is on page number 11, my lords. My lords, the brief facts of the case are such, my lords, that the appellants are the proprietors of a proprietary concern, namely Rajashri and Company, my lords. The said proprietary concern, along with 11 other proprietary concerns, had taken a loan for an amount of rupees 20 crores, my lords, 20 crores, 2 lakhs, my lords, from the respondent number 4 bank, my lords. The respondent number 4 bank is a cooperative bank, my lords, which was registered under the Banking Regulation Act 1954, my lords. My lords, the said bank, my lords, the said loan accounts, my lords, originally were were term loan accounts, my lords. Thereafter, the same were converted into OD accounts, my lords.
My lords, the said amount that was obtained was for an amount of rupees 20 crores.
What happened? You did not pay the amount, right?
Yes, my lord.
Then what?
My lords, there was a property in Begumpet that was attached as that was mortgaged for purposes of recovery of the loan amount in the event that there is default on part of the proprietary concerns, my lords. Subsequently, my lords, the bank.
Then it was sold, right?
No, my lords.
What happened? What is the order under challenge?
My lords, the order under challenge, my lords, is a memo issued by the registrar, my lords. Registrar of the cooperative societies, my lords. The said.
What?
My lords, the said impugned memos on page 72, my lords. A brief description of what preceded this, my lords, is required.
No. That's correct. We will hear you. I mean, but we just want to know what was the writ petition about. What,
Yes, my lords.
you should briefly at least 2 lines tell us.
Page
Otherwise we will
73,
read.
my lords. The neater version is available on page 73, my lords. These are the proceedings that are issued by the government, my lords. Thereby, the said property was directed to be sold to a private purchaser, who is the respondent number 5 in the present appeal, my lords, for an amount of rupees 23 crores, my lords. This only on the basis that the said proposed purchaser had offered a higher amount, higher market value than what was being offered in the previous years, my lords. There was no public auction that was conducted for the sale of the said mortgage property, and this was completely against the provisions as prescribed under the Cooperative Societies Act, my lords.
What your mortgage property has been sold, right?
Yes, my lords. The mortgage property has been sold.
So, like, what is the challenge on that procedure prescribed for sale has not been followed?
Yes, my lords. The procedure prescribed under the Act, my lords, under the Cooperative Societies Act has not been followed. My lords, in the meantime as well, my lords.
Why your petition has been dismissed? What was under challenge? What is the memo?
The memo was under challenge as well as the subsequent sale, my lords, in favor of.
What is the memo 18/4/2006? What is 18/4/2006?
873, my lords.
What is it, madam?
My lords, it gives the permission to the person in charge committee of the respondent 4 bank to sell the mortgage property in favor of the respondent number 5, my lords. However, the sale was not only made in favor of respondent 5, but also respondent 5 to 11, which is also under challenge in this writ appeal, my lords.
Yes. Why your writ petition has been dismissed?
My lords, the writ petition has been dismissed on multiple set of grounds, my lords. Number 1, my lords, is that the learned single judge has stated that has held that the said procedure contemplated under the Rule 52 of the Cooperative Societies rules is only limited to execution petitions filed under the arbitration initiated under the Cooperative Societies Act, my lords. However, my lords, there is no procedure prescribed in those circumstances where a cooperative bank is sought to be reconstructed or restructured, and in those cases when recovery process is to be initiated, my lords. In those manners, in those circumstances, there is no prescribed procedure. Hence, the procedure that has already been prescribed in the Act, which is exists under Rule 52(1)(11)(f), my lords. My lords, I may be permitted to read the same, my lords.
No, we just wanted to know gist of now you can tell the facts.
Yes, my lords.
So the 2 grounds you are challenging, that the procedure prescribed under the Act has not been followed.
Yes, my lords.
And the sale was given only in favor of respondent number 5. However, it was sold to 6 to 11 also.
5 to 11 as well.
5 to 11.
Apart from that, my lords, the public auction, which is in essence of the cooperative movement, my lords, where the said mortgage property had to be put up for auction, my lords.
So, object of the cooperative movement is to recover the money lent by it to others, and not to let the borrowers flee the country.
Yes, my lords. But by settling for an amount that was much lesser than the real market value, my lords, only in circumstances that a prospective purchaser had approached and earlier.
Madam, there has to be a remedy under the Act. Definitely, under this action is taken against you under Cooperative Societies Act for sale.
My lords, we had challenged the bank had filed a recovery case, my lords.
which was the award, under the arbitration proceedings, my lords. An award was passed, my lord, which was upheld by the the tribunal as well, my lords. Subsequently, all these notices that were issued, though they say that they have been served on us, the arbitration proceedings notices have been served on us.
Like
we've
you
not
go
received
ahead in
any.
your own way. Please go ahead.
Yes, ma'am.
In your own way. Tell us the facts now.
My lords, the brief facts, I may be permitted to pass across a list of events, my lords. My lords, the fourth respondent bank is a society registered under the under the AP Cooperative Societies Act, my lords. My lords, the said appellants in this present appeal, my lords, apart from them, another 11 borrowers, 11 loan borrowers had approached the respondent bank, my lords, to obtain a loan amount of rupees 20.02 crores, my lords. In respect of this loan, my lords, the property that was offered as mortgage, as security for the said avail loans, my lords, was a property situated in Begumpet village, which was at measuring 7,528 square yards. The said property originally belonged to respondent numbers 12 to 14. My lords. The said respondent numbers 12 to 14 executed memorandum of deposit of title deeds in favor of the bank, and the said property was placed under the was placed in possession of the bank. My lord, subsequently, the appellants, along with the other 11 borrowers, defaulted in payment of the loan amount.
All these facts not mentioned in your list of dates and nothing.
My lords, page, the first item, my lords, is on 10th July 2000. Mortgage was created by the respondent numbers 12 to 15 in favor of the respondent 4 bank. For the loans availed by the petitioners and the 9 others, my lords. This is available on page 80, my lords.
No, there is no dispute about the mortgage.
Yes,
right?
my lords.
So
Yes,
we
my
need not go.
Yes, my lord. My lord, subsequently, the respondent bank faced severe liquidity problems, and hence the RBI had to intervene, and it issued certain directions to for the reconstructing of the respondent bank, and it directed the bank to take measures to recover the loan amount, to recover the entire amount of rupees 20 crores by selling the property. These directions were issued by the RBI. My lords, in the interregnum, the respondent bank also proceeded to file an arbitration before the district cooperative officer, my lords. And thereafter, my lords, the award was passed in their favor. Subsequently, because the RBI had issued these directions, the respondent 4 bank proceeded to.
These facts are not mentioned. All this is not mentioned, but what award, etc. you are arguing, it's not here.
My lords, if I may be permitted to give a
No, what?
further elaborate.
Why further? So how you have given us this and award, etc. is not mentioned. So we are finding where is it? Where is the award? Nothing. See for yourself. Where have you said who has passed an award? Nothing. In your list of dates and events. That is incomplete then.
My lords, I may be permitted to. The award that's not been placed in the
No.
writ papers.
All right.
I may be permitted to proceed, my lords.
Give us 5 minutes then. This. See, that's why he has applied. Sale 11/2006 petition filed after 3 years. What they were doing. AP Cooperative Society rules.
My lords, after the Reserve Bank of India issued the directions, my lords, the person in charge committee that was appointed for the respondent bank took the steps to put up the said mortgage property for auction, my lords. In the year 2003, it was offered for an amount of 11,500 rupees per square yard, my lords. Subsequently, the amount increased by a few thousands, my lords, and thereafter, only in the year 2006, my lords, did the respondent bank receive an offer from the respondent number 5, which was for an amount of rupees 30,500 per square yard. The said amount, my lords, was never corroborated by the bank to ascertain whether the same was the appropriate market value that ought to have been received for a property that was supposed to reconstruct and restructure the bank. My lords, thereafter, the respondent bank proceeded to sell the property in favor of these the respondent numbers 5 to 16, 5 to, I apologize, my lords, 5 to 11. My lords, this was done with the consent of the mortgagors, my lords, who had originally provided the said property to the FLNs and 11 others, my lords, as a security. My lords, when the said property was sold, the said sale took place without a public auction being conducted. In the earlier years, my lords, the said property was put up to auction. The said step to sell the said property, my lords, was taken in pursuance of the recovery proceedings, my lords. The recovery proceedings which ought to have been initiated by the bank once the arbitration award was granted in their favor, my lords. But instead of going by the procedure laid down under law, my lords, by stating that the Reserve Bank of India has directed them to take urgent steps to recover 20 crores for restructuring the bank, a procedure that is not prescribed under law was followed. And the said impugned memo was issued by the government, my lords, which had no authority to do so. And there is no specific procedure under which the same has taken place, my lords. My lords, the other difficulty, my lords, that the petitioners are facing is that the said amount that was recovered, which is an amount of rupees 23 crores, my lords. The said amount, my lords, was only adjusted against 2 out of the 11 loan accounts. The said 2 accounts, my lords, were recovered, it was adjusted in total, my lords, whereas for the remaining 9, my lords, it was only adjusted in respect of the principal amount. The leftover, the balance amount that had to be recovered, my lords, the government directed the bank to proceed under recovery proceedings against the appellants, my lords. My lords, there is no reason given for the pick and choose method appointed by the bank, my lords, in choosing only 2 loan accounts out of the 11 accounts
to adjust the recovered amounts. My lords, apart from that, my lords, because the procedure has not been followed, because the petitioners were not given an opportunity, the appellants, my lords, were not given an opportunity to be heard. Just because the mortgagors had consented to the sale, my lords, would not mean that the petitioners' interest would not be protected, my lords. Because the petitioners had ideally agreed for the property to be mortgaged, because they were assured that the said property would provide them enough security to recover their liability. My lords, in that circumstance, the government or the bank cannot state that only rupees 23 crores is, can be recoverable from the sale of this property, and hence there is no need to put the same on for public auction. My lords, there is another fact that I would like to bring to your lordship's attention. The page number 78, my lords. My lords, it is not the case that there were no other offers at that point in time, my lords. Page number 78, my lords, there is a clear offer by another third-party purchaser, my lords, who had written to the respondent bank, offering to purchase the same property, my lords, for an amount of rupees 27 crores. The amount of 27 crores and 23 crores is 4 crores apart, my lords. However, the 4 crores could have been also adjusted against the other loan accounts, my lords. Therefore, by picking and choosing and by getting the consent of the mortgagors, my lords, the respondent bank or the government cannot say that the petitioner's interest ought not to be protected and that they have approached the Honorable Court belatedly. They have approached this Honorable Court only when the said execution.
After 3 years.
Yes, my lords. Only after the said execution was brought to the notice of the appellants, they have approached this Honorable Court.
Notice who brought to the notice? What were you doing when it was being sold? Who brought to your notice?
My lords, at that moment, my lords, when we made inquiries, thereafter it came to our knowledge, my lords. Until then, we were under the assumption that the said properties are still being put up for public auction. The same were done in a clandestine manner, I may say so, my lords, but it was done in a manner in which I was not put to notice. Only the consent of the mortgagors was taken, and they were.
You are a guarantor to the transaction.
Yes, my lords.
You are a guarantor.
No, my lords, I'm the borrower, my lords.
Borrower.
I'm the borrower.
The persons who own the property and who had mortgaged it for you, their consent was taken.
Yes, my lords, but I had secured the loan only.
What were you doing for 3 long years, madam?
My lords, I was kept in the dark, my lords. I was not aware of this arrangement that was made.
What else?
My lords, the point that may be considered, my lords, may be in respect of the adjustment towards only 2 loan accounts, my lords. In respect of the other loan accounts, my lords, because the memorandum of deposit of title deeds was in respect of.
Have you read the order passed by the learned single?
Yes, my lords, I have, my lords.
What reasons has been? You have to, in an intra-court appeal, madam, you have to tell us what grounds your petition has been dismissed and then tell us how those grounds are not made out or are incorrect.
My lords, in
You have, he has learned single assigned rule 53 does not apply to fact situation of the case. That
Yes,
you have
my
not told anything about it. You have not even read the provision. Then delay and laches, he has said that 3 years delay and laches, no relief can be granted. Last paragraph, he has addressed this very argument with reference to provisions of Contract Act.
Yes, my lords. But,
What yes means?
but my lords,
Yeah, again, you are arguing the same thing, same arguments which have already been rejected.
I apologize,
You have to,
but the fact remains.
no,
that it
so
needs
therefore you have to, how you have to point out that first that this thing rule 5311 applies. Then this thing, then there are no delay and latches. Third, this finding which has been assigned in the penultimate paragraph of the judgment is incorrect in law.
My lord,
This
I
is
may
what
permit to read
you are
two, my lords.
same arguments you are raising which have already been rejected, right? These arguments have been rejected by learned single judge.
My lords, rule
That's why you are in appeal. Correct?
My lords, Rule 5211F clearly permits the said property to be sold only by way of a public auction, my lords. There is no other way that is contemplated, my lords. There is no procedure established under law whereby the RBI can direct for sale of the cooperative society.
Yes. Yes.
My lords, Rule 5211F, my lords, of the AP cooperative rule. Rule 52. F. I may be permitted to read, my lord. I may be permitted. When any immovable property is sold under these rules, the sale shall be subject to the prior encumbrances on the property, if any. The decree holder shall, when the amount for realization of which the sale is held exceeds 100 rupees, furnish to the sale officer within such time as may be fixed by the sale officer or by the registrar of the district an encumbrance certificate from the registration department for a period of not less than 12 years prior to date of attachment of the property sought to be sold, or in a case falling under the proviso to sub-rule 10 prior to the date of the application for execution. The time for production of the encumbrance certificate may be extended at discretion of the sale officer or the registrar of the district as the case may be. The sale shall be by public auction or e-auction to the highest bidder, provided that it shall be open to the sale officer to decline or accept the highest bid where the price offered appears to be unduly low or for other reasons, and provided also that the registrar of the district or the sale officer may in his discretion adjourn the sale to a specified day and hour, recording his reasons for such adjournment. My lords, the said sale which ought to have
Read when does Rule 52 apply?
My lords, the rule 5211F would have applied, my lords, in case the cooperative bank had pursued its remedy under the execution proceedings, my lords. My lords, just because an award was passed in their favor, my lords. After the award was passed in their favor, the reasons given by them for not proceeding with filing the execution petition is because for pursuing the execution is because certain claim petitions were filed in the said execution petition, my lords. Thereafter, in the meantime, my lords, very conveniently, the Reserve Bank of India comes in, my lords, and issues directions to the cooperative bank, and that does not mean, my lords, that they do not follow the procedure contemplated under law, my lords, for the sale of a property, which has been mortgaged with the cooperative bank. The entire procedure that ought to have been followed by way of the execution petition has been circumvented. If that hadn't taken place, they would have had to go through this public auction, and there were attempts made earlier for public auction matters in the year 2003, 4 and 5 matters. Subsequently, in the year 2006, just because the respondent number 5 has approached them, in what manner and why respondent number 5 was chosen over and above other prospective purchasers remains to be examined, my lords, which the learned single judge has not considered in his order, my lords. It's my most respectful submission, but the same has not been followed, my lords.
That's all.
Yes.
Please, your lordships. Lord, I represent the purchaser, that is respondents 5 to 11. Lord.
the petitioner before your lordship does not have interest in the property. They are mere borrowers. They are not the owners. The owners are the respondents 11 to 15. They are the owners. And the
Owners are
the respondents 11 to 15. My lord. I'm sorry, 12 to 15. 5 to 11 are the buyers. 12 to 15 are the owners. My lord. Petitioners are the borrowers. They don't have any interest in the property. They were defaulters. The bank had obtained order award against them that was confirmed in appellate proceedings, and in execution of the award, auction had held for 3 years. From 2003 onwards till 2005, the bank made repeated attempts to auction the property, but there was some where the auction was being scuttled. And finally, my lord, after 3 years of efforts, the respondent had offered to buy the property because they were looking for a property for constructing a hotel in Hyderabad. My lord, they had made an offer. By then the bank was already in severe trouble, and the RBI had given certain guidelines that first they need to recover at least 20 lakhs they identified this particular property to be sold. RBI had issued directions, please make an attempt to sell this property, and then a person in charge committee was appointed by the government. The committee made these attempts for selling this property for 3 years. They were unsuccessful. Then we made the offer. Then they found that the offer made by us, it was the committee is headed by the joint collector and other district officials. They examined the offer, found it to be in tune with the market rates at that point of time, and then they forwarded the offer to the commissioner. The commissioner in turn took sent it to the government and obtained the approval of the government. Only then the sale was made, and the condition clearly imposed by the government was that the entire consideration has to be paid directly to the bank. No amount is to be paid.
Order?
My lord, that your lordship will get it at page 73, my lord. This is the memo that they are challenging. And that too after 3 years, my lord. They came to the court 3 years after the auction was conducted, after the money was adjusted to the accounts. Now the only grievance is their real grievance is that interest, so far as the interest portion is concerned, it was appropriated to two accounts and some interest was not adjusted to the petitioner's account. That seems to be the grievance that they've come after 3 years. My lord, by then we had already commenced construction, we had done excavation, and construction had progressed to some extent. My lord, at this stage they approached this court and then challenged this memo. May I read, my lord, page 73? The attention of the Commissioner Cooperation and Registrar of Cooperative Societies is invited to the reference cited. He has informed that the Begumpet land was put to auction thrice during 2003, 2004 and 2005, and the highest offer in the 3 auctions was 11,600, 14,500, 25,000 per square yard. The auctions during 2004 and 5 were conducted under 3-member committee with the Joint Collector Rangareddy and person in charge members of bank as members. The bank could not get more than the amounts mentioned in the auction. Now the rate offered by Jia Tangamalagai Private Limited Chennai is 30,500 per square yard, which is in conformity with the market trends as mentioned in the proposal. The Reserve Bank of India felt that there is a possibility for reconstruction of the bank provided that the bank achieves 4 goals. One is if it is recovers at least 20 crores from the sale of properties mortgaged to its bank situated at Begumpet Road. The person in charge committee of the bank resolved to permit the mortgagors to sell the Begumpet property to the buyers of their choice. The Law Department opened the Supreme Court has made it clear that nothing said in the order shall prevent the banks to enter into settlement with the debtors in accordance with the law. Further, as per the Supreme Court, if any amount is recovered from or paid by the judgment debtors to cooperative banks concerned in view of the stay grant shall be open to the seek appropriate relief from the bench finally hearing these matters. Therefore, in view of all angles.
Where is this 23/12/2005 commissioners, this thing? Proposal which has been accepted by the government. Mr. Please do this thing, right? A synopsis sort of thing you should help, right?
Yes, madam.
Date wise at least mention.
My lord, the commissioners is at page 75.
Give tomorrow. You are continue, but give tomorrow that is for the this thing to facilitate dictation of the order. Nothing.
Lord,
I appear for the
my
respondents.
lord, then considering the submissions, if your lordship will kindly see page 45.
Only 75 is something else, Mr.
My lord, your lordship inquired regarding the commissioner's statement. That is the letter, my lord, commissioner's statement.
This is government of Andhra Pradesh. Dated what is? It is 23/12/2000.
The commissioner of cooperation
to
the managing director.
Which has been accepted.
Yes, my lord.
In that page 73
Yes,
order.
my lord. Yes, my lord. That it appears the petitioner has not filed, the appellant has not filed this. That
You
letter-
give us along with synopsis tomorrow.
Yes, my lord.
Yes.
I'll see if I have a copy.
Yes.
My lord, so far as the order of the learned single judge, may I draw your lordship's attention to page 45. Page 45, para 19. May I read, my lord? With reference to the above arguments advanced by the learned counsel for the parties, the issues which arise for consideration are whether the sale of immovable property in favor of the respondents filed to living basing on the orders issued by the government dated so and so and constitutional orders dated so and so is in violation of the provisions contained in 53 of the AP Cooperative Society rules. Secondly, whether the delay and latches on the part of the petitioner is approaching this court, which designed them to relief under 2.6, and further, whether the fourth respondent is justified in adjusting the amounts in full in respect of the two accounts and principal amounts in respect of the other accounts. These were the three issues identified by the learned single judge. And then, my lord, the discussion proceeds from page para 20 onwards. My lord, so far as the first issue is concerned, the learned judge held that there is no question of violation of Rule 52 because it was not in execution of the award. It was through the permission of the bank and the owners of the property that was this sale was conducted. Therefore, the procedure under Rule 52 would not apply. On that is the ground, my lord, on which the learned judge had decided that issue. So far as the second ground, my lord, as your lordships has seen, after the property was sold, the petitioners were well aware that the principal amount was adjusted. So their delay in 3 years is totally not answered. They had kept quiet deliberately. Some civil suits were filed by them against the parties. After losing their ballot, after 3 years, they came and again started this and obtained an order against us. The order after we entered, then the matter was closed and then we proceeded with the construction. My lord, so far as this third aspect, my lord, adjustment is concerned, my lord, the learned judge has held that so far as the principal amount has been adjusted against all the accounts, interest was adjusted for two accounts and it is the right of the bank to do so. My lords, these are the three grounds on which the learned judge has dismissed their petition. Now, my lord, so far as the locus of the petitioners to challenge the sale of the property, my lord, they have no interest, right, or title in the property. They are merely borrowers against whom already a confirmed award has been passed and it has been confirmed in appeal also. So therefore, they had no right in the property to challenge the sale of the property. If at all, it could have only been done by the owners who are respondents 12 to 15. So on that ground, my submission is that first of all, they have no locus to challenge the sale of the property. And so far as the delay, my lord, clearly there's a delay of almost 3 years and they have only come to scuttle the process and try and create hurdles in. And the third ground, my lord, so far as their issue is concerned, so far as adjustment of the bank, if we ever really agreed, then the remedy was not filing a writ petition challenging the memo. The remedy should have been to approach the bank. They slept for 3 years over the matter. And then via in indirect way, they try to challenge that aspect by raising the question of validity of the memo issued by the government. Their real grievance seems to be that part of the interest was not adjusted to them. That is what my learned friend is now also pressing for before your lordship. So on these three grounds, my submission is that there is no error in the order of the learned.
Give us an office. We'll continue tomorrow. Yes.
With your lordship's leave, my lord, I am appearing for response 12 to 15, my lord.
Yeah.
My property was sold. We are
And
the
you-
borrowers. And if your lordship kindly sees page 52 onwards, the learned single judge has pointed out that there is no grievance to the owners of the property. It's a matter between the borrower and the borrower, borrowed and the borrower, and they have agreed for the, because they could not get a better sale. Now, after sales are effected and after it's confirmed,
So
after
who are
issue
the
of the government
appellants, Mr.?
orders,
Who are the appellants?
Well, its appellants have been borrowers, defaulting borrowers.
So he is also saying why I
It's appealing for the owners, my lord. That is quite different. The owners.
I am the owner of the
others means what? Like they are also borrowers.
They were also
Some of the borrowers.
There were a number of accounts, my lord. There were 11 accounts. Out of them, some of these were.
So they are some of the borrowers.
Sir, the mortgagors, man.
There are very, yes. We are the persons who obtained the loans, who mortgaged the property and whose property was sold, and our loan accounts were settled, no due certificates were issued, and my property is in the possession of the purchasers, and they developed the land. After lapse of 3 years, now the present writ petition is filed by other buyers, saying that money should have been appropriated to their account also, which is not permissible in the Contract Act. The borrower has nothing to do with the property sold. The writ petitioners have nothing to do with the property sold. The property sold was belonged to us. We were the borrowers and we were the owners, we were the mortgagors. Mortgagors and the mortgagee agreed for sale of the property and liquidated the liability. The other borrowers cannot say that sale proceeds you adjust to my account.
So that should be.
Am I audible, madam?
Ah, yes, we are.
Yes,
Yes,
I'm
we are looking at you
Because this
because
is-
you have. Yes.
Because I will some connectivity problem.
No,
My
connect.
submission is from page 52 onwards.
You ask him what.
Yes, sir, but there is a finding to the extent that.
It's not audible.
Yes, counsel, are we audible? You can also answer this because see the borrowers and the owners who have jointly obtained the loan jointly and severally liable.
Yes, ma'am.
So if it is has to be apportioned, it should be apportioned equally. Why they have chosen only two accounts?
No, my lord, what I understand is that because, my lord, I am the purchaser, so I am not aware of the details of the adjustment that is between the bank and the petitioner. But what I understand from the record is that the principal amount in all accounts was adjusted. Interest was adjusted in some of the accounts. So, because probably there was insufficient amount to cover everything. So that seems to be one of the grievance, but that is a grievance that they ought to have raised 3 years back when the adjustment happened, not slept over it for 3 years and then challenge it in the course of challenging the memo and then invoke the 226 jurisdiction. Well, that was under the Cooperative Societies Act or rules, they ought to have challenged it. So that ground can never be raised, my lord. My respectful submission in the writ petition.
And concluded that the writ is
Yes, go ahead. You're not saying anything. No, it's pleased. What they are connected by mobile or something. Sometimes low. At their this thing. At their end. That's it, mister. Anything else?
Sir, Am I audible, my lord? Am I audible, my lord?
No, no. Yes, anything else? The moment we say anything else, he asks. Otherwise, he doesn't respond. See. Yes, madam.
My lords, only one.
So you give us this thing, list of dates, we will list it tomorrow. List for further hearing tomorrow. Which other case? Just trying to ascertain whether anything, because they won't say anything. Yes, madam.
I beg to represent Shri Ugrana Simha, my lords. I am for the appellant. The present writ appeal is pertaining to Andhra Pradesh, now Telangana, Agriculture Land Conversion for Non-Agricultural Purposes Act 2006, my lords. The brief facts of the case are the property in question. The property in question belongs to my father, my lords, who expired on 15th November 2003. My brother and myself are sole legal heirs, and by virtue of registered will dated 27/6/2003, myself and my brother succeeded to the property to the said extent, my lord. With a view to develop the land, my lords, we made an application to respondents to develop the property, my lords. To that effect, respondents has issued a letter dated 12/2007, my lords, by directing us to get a no objection certificate, my lords, from collector.
Covered in favor of the petitioner. Item. Yes, madam, are you aware? 53. What you show her?
My lords, there are batch of writ appeals, my lords. There is a covered judgment of this Honorable High Court Division Bench.
That's what he's saying. In your favor, madam.
Yes.
In your favor.
Yes, my lords. Yes.
Give it. Yes. Whatever. Yes.
My lords.
Yes. This inter-court appeal has been filed against an item, madam. This was 58. See, you have got up. That's why I asked her to call. They wait. No, they could have told it. Yes, 59. 59 to 65. What is the batch? Huh? Huh? ROR Act? Huh? Huh? We will continue tomorrow, hardly any time. Your appearance means, I mean.
No, it doesn't mean anything, my lord. It only 10 minutes case. Only 10 minutes.
No, your appearance means, I mean, the matter survives for consideration and has to be heard. Whatever, it may take even 5 minutes also, we don't know. Yes.
My lord, may I be permitted? But in the item number 64 and 65, my lord, the petitioner
You want to withdraw?
No, my lord.
Then
64 and 65.
don't seek an adjournment. And why?
No, my lord, I'm appellant in 62, 63. 64, 65, counsel, my lord, he said he's in US, went for some treatment, coming back after 4 days.
Huh?
He informed me, my lord, maybe taken up anytime next week, my lord.
People see Mr. Senior Advocate of this court, Mr. Vidyasagar, had gone to US and he has addressed us on so many occasions from video conferencing from US, right? So when a senior person like him can appear, how can you this be a ground?
He requested me, my lord. I'm appellant in 62 and 63.
You argue your own case. Nobody is there requesting. And he is there, no, Mr. He will senior.
In my case, he is the respondent.
Respondent. Let's see tomorrow. Why to adjourn it today?
Yes, sir.
By tomorrow, you may come up with a better idea to address us, right?
Yes, sir. Okay.